Hi students, I welcome you all to the Marathon for Company Law. Thank you so much for your patience and being there with us. Now remember, I'm going to cover one of the most important and the highly weighted chapters in this marathon. The full chapter will be completed. Now before I start, I wanted to hit the like button and share this video with your friends as well, okay, in your study groups as well. So can I have GTG in the chat box? Am I audible and visible so we can start and complete this entire chapter for you? Okay, great to have this enthusiasm. Okay, yeah. So what is the plan for today is I'm going to cover every single exam question also for the chapter share and share capital, which is your lesson 4, the biggest part of your chapter of your part A. I've covered a full sections marathon last time, and this time I'll be covering the full chapter. So I want you all to be attentive with me. Complete this chapter. You can open your modules. These notes I have shared it in the JT community group. Okay, so you need to join the community group. Okay, it is there. You will get these notes completely from which I'm teaching. So in case if you don't have this, also referring the module is sufficient because these notes are made exactly from the module. So good to go. Yes or no? Can I have GTG in the chat box? Exemption in the chat box? Yes or no? Okay, and thank you so much for the amazing response for the dream batch. Like always, around 250 students in 2 days have enrolled for the dream batch. The dream batch gives you access to the paid lectures at a price less than a pizza. So this always I do it so that I can help so many students, maybe self-study students, those who don't have access to classes, or those who might be stuck in some classes where they are not able to understand, or they are stuck somewhere. So that time this gives them the final boost of clearing and achieving the dream of becoming a CS. So before I start, can I have a GTG in the chat box? Yes or no? Am I audible and visible? Yes. So then I'll be excited to start. Yeah? Okay, great. So in your part A, there are multiple chapters. Part B, there is meeting directors, and your full part B gets over. Part A is 60 marks. But do you know from that 60 marks, around 15 marks comes from your share and share capital. 15 marks comes from share and share capital, which I am going to cover today. Okay. Shri, great to have you. Okay. Dolly, great to have you. Chalo, let's start. Hi, we'll be starting with a chapter called as shares and share capital. Now, this is the most asked chapter, or you could say highly weighted chapter in your part A of company law. It comes for around 15 marks in your examination. So let's start. Now, what is this chapter about? So your chapter is divided into 5 parts. The first part is very basic, telling what is a share, what is a share capital, okay, and equity and preference, and the types of equity and preference shareholders. Great. So we'll be understanding what is share capital, classes of share capital: authorized, subscribed, issued, that part, difference between equity and preference and the types, and about share certificates. Next is your part B. The part B of the chapter talks about basic terms with respect to issue and allotment of securities. So they are going to tell you what is the difference between share and securities. Then how can you raise money from public through prospectus, and there are different kinds of prospectus in company law, like your red herring prospectus, your shelf prospectus, abridged, offer for sale, which is called as deemed prospectus. And then they also talk about share certificates and duplicate share certificates to get, and your on purchasing of the shares, or you get share certificates. In case you misplaced it, you get a duplicate share certificate. So the procedure we'll be seeing. Then part C is about issue and allotment of securities. This is an important part because they tell you the various types of issues that can be done. Issues means what? We know we can issue shares, but you can issue preference shares, you can issue sweat equity shares, you can issue shares with differential voting rights, or private placement can be made. Okay, bonus shares can be issued, right issues, ESOPs, all of that, DVRs, preference shares, all of that comes here. Whether you can issue shares at premium, discount, okay, and all the provisions governing issue and allotment of securities. Then in part D, you're going to learn about alteration of share capital. Alteration of share capital, you would see your alteration, that's section 61. You will see buyback, you will see reduction of share capital and diminution of share capital. Okay, so these are the types that we will be seeing. And in the last part, they talk about transfer and transmission, that is called as transferability of shares. How do you transfer shares in case of private company, public company, the stamp duty that is levied, and the concept of transfer, transmission, and also they talk about materialization and rematerialization of shares. So the chapter is divided into 5 parts. So let's begin with the first part of the chapter. So we begin with the first part of the chapter, that is part A, which is called as meaning of share and share capital. Now before we try to understand what is the meaning of capital, so capital is not defined in the company law, it is just understood by common understanding. So if I ask you what do you mean by capital, so capital is the funds raised by the company. We are going to talk from company law point of view that businesses require funds. So the total amount of funds or financial resources acquired by the company is called as capital. These resources you can raise from 2 sources, either own funds, that is called as equity capital, or debt funds, which is called as debt capital, taking a loan. So a company can raise money through, raise capital through owned or borrowed funds. Now, what is the meaning and definition of share? And what is the meaning of securities? So, okay. So, we'll be looking at share. So, what do you mean by the term share? So, if you go to see how do you define it? So, firstly, knowing the section is important. Share is defined under section 2 subsection 84. What does it say? A share, if I talk that this is the total funding or the assets or the profits of a company. If it would be a sole proprietor, this entire pie or this entire benefits will be taken by one person. If I say it is a partnership firm, so there are 2 shares, let's say there are 2 partners, so there will be 2 shares, okay, and equal partners, so 50-50 each one will take. In a company there are multiple partners, they are called as members or shareholders, multiple. So when you take one, so when you buy one share, so it could be this. So what is it? It is a share, is one share from the entire share capital of the company. So share means a share, a small part of the share capital of the company. Okay. Now the nature of shares. Nature of shares means what? Is share movable property or immovable property? And can shares be transferred or it cannot be transferred? Obviously today if I buy shares of Reliance Industries, I can sell it the very next day. So these are transferable. Okay, and they are treated as movable property. They are treated as movable property. Where is this given? It is given in your section 44, which talks about the nature and characteristics of a share. So share is movable and transferable. Very, very simple. Now when you go to see, there is distinctive numbers. Now physical share certificates, when you ever if you've seen a physical share certificate, on that a specific distinctive number will be given. So every share may be identified by its distinctive number. Okay, but if the shares are held in electronic or Demat form, then distinctive number is not there. Obviously, online shares you don't see any distinctive numbers. Distinctive number is on shares, physical share certificates. Now coming to an important part called as classification of share capital. What we are going to see, classification of share capital means the total, if I just bring this to the authorized capital, or they call it as a nominal capital. So you can make this, what are we seeing? The very first one, we are seeing the capital, the total money that the company has is called as capital. Financial resource that they have is called as capital. The maximum amount that they are allowed to raise is called as authorized capital or nominal capital. This is the maximum that they can go and raise, limit. For example, if the maximum amount that you're allowed to raise is 10 or 100 crores, example, you have been given a power that you can go ahead and raise from the public 100 crores. But you might not need 100 crores. So from here, you will issued capital. So you might just require, let's say, 80 crores. You might only require 80 crores. So you go ahead and issue. Just because you made an issue, you made an offer to the public, doesn't mean that they will subscribe. So let's talk about subscribed capital. So once you have offered, and we are looking at the how many people have subscribed. Let's say 75 lakhs or 75 crores has been subscribed. Now how much ever has been subscribed, so they are ready to pay that much amount. But company might not need all at one go. So what they can do, they can called up amount. So you can have called capital. So let's say we have just called 50 crores. So 50 crores is the called amount, is the amount that we have asked the shareholders that listen, out of your full liability, please come and pay this much. Clear? Called capital. The rest amount will be treated as uncalled capital. So this is the hierarchy, is the concept clear? Authorized, issued, subscribed, called. Simple. Goes in that order. Let's look at it and complete it. The maximum amount that the company is allowed to raise, is called as authorized capital, nominal capital, or registered capital. Issued. Now issued capital is from the authorized, only a portion of it will be issued, that is offered to the public to subscribe. Now how much the public have agreed to subscribe is called as subscribed capital. Then how much did the company called up? Now also one last point we can write, that even if I have called up, let's say in this category, further I can have this point, you can note it down, that if I have called 50 crores, do you think everybody must have paid up just because you have demanded the money that listen, you all had promised 75 crores, from that give me 50 crores. Maybe someone must have not paid. So we have paid up capital. So paid up capital will be, let's say 40 crore people have paid up. So in your entire company law, you will notice this word given, paid up capital, asked many times. Why? And why is it more important? Because this is the actual amount that the company really has in their reserves or in their profits or in their custody. Because that is the real amount people have already paid to the company. So paid up capital is very, very important. Okay. Now, going to the next thing. So we always have been knowing in commerce what is equity and preference. So from the name itself, both of them, now pay attention to how I'm going to teach you, that both of them are shares. Both of them, if you go to see, this is equity shares, and if you go to see, this is preference shares. So shareholders are the owners of the company. They are the owners of company. So the profit is also theirs, the losses are also theirs. Now if you go to see that as per company law, because now we need to know sections also. So as per company law, under section 43, there are only two classes of shares that are there. So there are only two classes of shares. So one is a equity capital and the other one is called as preference share capital. So how many classes of shares are there? There are only two classes of shares. One is equity and the other one is preference. Sir, how do you define? Now there are only two. This is the first and this is the second. If I ask you, what do you mean by the term equity share? So equity shares, they have defined as those shares which are not preference shares. So which is not preference is considered to be equity. And then when you go to what is preference, but preference they have given properly. Preference means they have a preference, they have an advantage, they have a preference over equity shareholders in two categories. Which are those two categories? One is at the time of payment of dividend and at the time of winding up of company. Very simple. So when the company is distributing dividend, first they will give to the preference shareholders and then they will give to the equity. If they are giving to the if same thing, winding up. So in winding up, what happens? First the preference shareholders are paid and then if the money is left, then they go to the equity. So this is how they have a advantage. If I give you an option that you can get equity or preference, which will you prefer? Obviously you'll prefer preference. So that is why preference shares are more expensive than equity shareholders. Very simple. Now in equity, pay attention. We know that now I'm talking about equity shares. Now equity shares have two categories. So if you go to see under section 43, what was section 43? That they said that there are only two classes of shares, equity and preference. Now in equity also there are two classes. One are ordinary shares and the other one is called as DVRs, differential voting rights. Shares with differential rights. So what are these? These are shares with differential rights. Now these differential rights could be with respect to voting, with respect to any time of payment, with respect to anything. Okay, let's take an example. Normally I can issue equity shares of 1 share 1 vote. These are normal. So here you will have 1 share 1 vote. So these are called as ordinary shares because this is the ordinary practice. But if I tell you 1 share is equal to 5 votes, so obviously these are differential voting rights. So how do you issue process to issue DVRs is very important. Okay, this is given in, we will come, it is in rule. Okay, which resolution is needed, what requirements are to be completed, how many DVRs can be issued, all of that. This is also a past exam question. Okay, now let's get into it. So equity share capital, equity shares includes with equal voting rights and with differential voting rights. Now differential voting rights also can be there, differential dividend also otherwise. Means what? I can have any kind of a difference between equity shareholders. One could be voting rights, which I have explained, 1 share 1 vote. Other equity shareholders are getting 1 share 10 votes. And with respect to dividend also, so they can also have that maybe this class of equity shareholders will get dividend first. Sir, how it can happen? Please give an example. So let me give you two examples. I'll not give you one, I'll give you two. I'll also give you with respect to each of them. Dividend also, I'll give you an example practically how it will be there, and also with respect to voting, how it will be there. First, remember this, I want you to remember forever, okay? For DVRs, any differential voting rights that are being issued, you require ordinary resolution. Which resolution is required? 51%, and you can do. Now what happens, let's say there is an investor who's coming, investor who has invested into the company. He's telling the other equity shareholders, listen, I'm entering into the company needs money at this moment. I will only come as an equity shareholder if I get some better preference as compared to y'all. So in equity shareholders only, first I will get dividend, then the other equity shareholders will get the dividend. So this is DVR with respect to dividend. With respect to voting, now if you go to see, Mark Zuckerberg had issued DVRs. In India, Tata Motors had recently issued DVRs. Like Mark Zuckerberg, what does he say? That listen, on my shares, one share will be 10 votes. And on your share, one share will be 10. One share will be 1 vote, and on mine, promoter will have one share 10 votes. Will you agree that promoters are having more voting rights on one share only? So many agreed, because what they said that, now pay attention, I'm telling you the logic, this is not given anywhere, I'm giving you the logic why shareholders will agree that someone else can get one share 10 votes. Because shareholders today always are concerned with money. They want more money. I invest in shares not to run the company, not to go and make decision making on what business. I care about my money. I invest money and I keep looking at my returns, that it is 12%, 18%. I'm concerned with the gain. So I can tell that, listen, I think this guy is smart. This promoter, Mark Zuckerberg, is really smart. Let him have on one share 10 votes, because he understands the business best. So if the business is running as per what he wants, there is more chances that we will make profit. Okay, so that could be one of the case where shareholders will agree someone else having superior voting rights. Okay, next, preference shares, as I told you, is the meaning is preference shares mean they have a preference over dividend and at the time of winding up of the company. Next, now preference shares, okay, to issue preference shares. Now you would say that you are interested in preference shares. So what is the process of issuing preference shares? It is given under section 55. Again, process to issue preference shares, is given under section 55. Okay. Which resolution is needed? So just remember, to issue preference shares, you require a special resolution. Next, it cannot issue irredeemable preference. See, redeemable means it has to be repaid within a given period. So it has to be repaid. Redeem means what? Repaid within a certain time period. Now what time period they have kept? 20 years. So, and for infra companies, since the projects for infrastructure projects are longer, they have kept 30 years. So again, preference shares, okay, are issued under section 55. They require a special resolution. They cannot be irredeemable, that a date is not given. That cannot ever be issued. Irredeemable doesn't mean that they will never redeem. It means that the fixed date is not given, or it is more than the time given. So always redeemable has to be issued and within the time period. 20 years in all our companies, and only for infrastructure company the time limit is 30 years. Now types of preference shares. Now what are the different types of preference shares? First is your cumulative and non-cumulative. This I believe everyone understands, but still let's go. Cumulate comes from the word accumulate. What does it come from the word? Accumulate. It means to gather. So if in 1 year company could not give dividend to the preference shareholders because of lack of profit, if in a given year company could not give dividend due to lack of profits, So every year they were getting 10 rupees, and then 1 year they didn't get. So that year they didn't get will be carried forward, and in the year they get profit, that will have to be given. That will have to be compensated. So the unpaid dividend gets accumulated, and in the year that the company gets the profit, they will have to pay it. Non-cumulative means it will not accumulate if the dividend is not declared in that year. The right to receive the dividend of that year lapses. It will not be carried forward. Convertible means they can be converted into equity shares, and non-convertible means they cannot. Participating means, just remember the word surplus profit. If the company will say that, listen, beyond this profit if I earn, I will give you one more dividend, like a bonus. So this will happen if the company only has surplus profit. So you are allowed to participate in surplus profits. Non-participating receive fixed dividend only. Even if there is surplus profits, they will get the fixed dividend only because they are non-participating in surplus profits. Redeem means they will be redeemed within a certain period. Okay. Irredeemable means they will not be redeemed. They will not be repaid within a fixed period. These are not permitted to be issued under Companies Act 2013. Now, coming to equity, we are still doing equity and preference. Now we are looking at equity shareholders and preference shareholders voting rights. What are we looking at? We are looking at two things: voting rights of equity shareholders and preference shareholders. My question to you, normally when AGM is conducted, who attends that meeting? Preference or equity? Today if you buy any shares online, okay, you go on your Demat account and you purchase. Okay, what are you purchasing? You are purchasing equity shareholders. Equity shareholders can vote on every single resolution or matter that has been presented. So they can vote on all. They will vote on all matters. Whereas preference shareholders will only vote on matters only when it concerns them or when their meeting is conducted. For example, if there is no variation in the preference shareholders, it doesn't affect the preference shareholder, then they will not be allowed to attend and vote in the general meeting. However, there is one extra point that for preference shareholders, which is given in section 42, that 47 subsection 2, that whenever their interest is affected, preference shareholders, they will be allowed to vote. So if it is a matters affecting their rights, winding up or reduction of share capital, even preference shareholders have a right to vote. And one point, that is a special provision with respect to unpaid dividend. Mark the section and subsection, also important. Section 47 subsection 2. What they are saying, that for if two consecutive, how many? Two or more consecutive, okay, that is also important, they remain unpaid for 2 years or more, then the preference shareholders will be allowed to vote on all the resolutions placed before it. Okay, and this right continues till the dividends are paid to them. So if dividends on preference shareholders remain unpaid, so if the dividend on preference shareholders remain unpaid for 2 years or more, then they get a right to vote on all the meetings. Clear? Then they get a right to vote on all the meetings, all the resolutions. Next. Now we're looking at compliance for publication of share capital. If a company mentions its share capital in any notice, letterhead, it must also disclose with equal prominence the subscribe and paid up. So normally you will always see the companies mention the subscribe, authorize, subscribe and paid up capital. With this, we have completed the part A of the chapter. Okay. Till here it is clear, yes or no? Write clear in the chat box, then I will go to part B. Like this, I will cover each and every part. Till here, was it clear, yes or no? Everything clear? Go through your module, mark everything as I am teaching you. write clear in the chat box. So I will quickly start with part B. Part B of the chapter. I'm waiting for you all to write clear in the chat box. And remember, I'm covering all the exam questions also which have come in June 2025 also. Okay, so I want you all to write clear in the chat box, go through your modules, see if there's anything, any doubt there, please put in the chat box. Otherwise, I will start with part B. So just waiting for 1-2 minutes for your response. Flip your module, see and complete it with me, and then I will start with part B. Write clear in the chat box if you flipped it from the module or the notes. Don't forget to like the video also, it's a very small thing, and write clear in the chat box. I want you all to be a little responsive so that I know that you all are participating. It just gives me more energy. Then I will start with part B and complete in one go. So 1.5 hours, be with me. I'm going to cover this full chapter in depth for you. I guarantee you nothing will come outside. And from the module, all the topics will be covered. 3 great, very good. Thank you so much. I want all of you all to keep responding. Okay. Let's start with part B. So just flip your module. I'll start with part B now. Okay, so let's begin. Okay, just keep your modules with you and see that I'm covering everything. I want you to just keep marking. Let's start. Hi, so now we start with part B, that is issue and allotment of securities. Now let's understand the part B, which talks about basic terms. Okay, now basic terms, first they start about securities. Okay, now securities is defined under section 2 subsection 81. Earlier we had seen the definition of the term share. Share was given under which section? Now I want to check whether you know your company law or no. I had told you all in part A what is the definition of the section for share. Now remember, we are seeing what is share and we are looking at securities. Okay, now securities is given under section 2 subsection 81 and shares is given under section 2 subsection 84. Okay, very good. Now we go to see securities. Now what do you mean by the term share and what do you mean by the term security? So share is a share in the share capital of the company. Securities is an inclusive definition. See, if you go to see, it is an inclusive definition. They say it includes all this. But when you really go in the definition, I'm going to teach you in a way that you know the internal definition also. Never have they directly defined. Okay, in company law, they are saying that when you go to section 2 subsection 81, they say share securities will have the meaning as defined under section 2H of SCRA Act. And when you go to section 2H of SCRA Act, then you come to know what is the definition of security. So in company law, when you open section 2 subsection 81, they are pointing towards section 2H of SCRA Act. They say that the definition given there applied here. So we go and we come to know that securities is a wide term. That security includes everything, including the shares. Including shares. See, what does securities include? So securities include shares. So when I say in the financial markets, you can invest in mutual funds, you can invest in derivatives, you can invest in CIS schemes, you can invest in AIF units, you can invest in REITs. Now all these things you might not know, you might just be knowing shares. but there are debentures, there are every single type of financial instrument is covered here. For example, your mutual funds, you don't need to know everything, but only in concept you need to know. It's a wider term. Okay, shares, debentures are covered, derivatives are covered, units of CIS are covered. All this you don't need to know. Slowly you'll come to know in other subjects as you upgrade. Okay, so government securities, any instruments issued by the government, everything is covered under the definition of securities. Okay, so thus security includes shares and is a wider financial. So securities is a greater term as compared to shares. Simple, very simple. Securities include shares, debentures, bonds, derivatives, mutual funds, everything. Now let's understand the meaning of the term prospectus. Now when a company goes to raise funds from public, okay, like let's say a company has gone and planning to raise money from the public. So they will have to issue a document telling the people that come and subscribe to my securities. That document by which the company is telling the people that these are my details, please come and buy my shares. That document is called as prospectus. Prospectus is defined under which section? Prospectus is defined under which section? So prospectus is defined under section 2 subsection 70. Okay. Now 2 subsection 70. Let's see. When you go to the definition of prospectus, very, very, very important. Okay. Very important. That a prospectus is defined under section 2 subsection 70. What does it say? That a prospectus is any document, okay, which invites offers from the public to subscribe or purchase the securities, where we are telling the public that please come and purchase our security. That document is called as prospectus. There are different kinds of prospectus like shelf prospectus and red herring prospectus. So prospectus includes two kinds of prospectus. One is given under section 31 and the other one is given under section 32. 31 is given under is about shelf prospectus. I'll tell you what it means. And red herring prospectus is given under section 32. Simple. Let's move ahead. Now we'll see the two things. Red herring prospectus. Now what is a red herring prospectus? I want you to write it down with me. Red herring prospectus is a prospectus that does not contain complete details of the price or quantum of shares issued, quantum of securities issued. They do not contain complete details. Instead, they don't even contain the price. They instead contain a price band. A red herring prospectus contains a price band that the price of our shares is 100 to 120. And they invite offers. They invite people to tell that what price they are ready to buy, and on basis of market demand, of the bids, market demand, that is called as bidding. People will bid. On basis of the bidding, the final price is decided. Final price is determined, discovered. Okay, is determined. Now it is a process of price discovery. They want to find at what price we should keep it at. So the red herring prospectus is issued and asking people to bid. On basis of the bidding, the final price is decided. This entire thing is issued under the book building process. It is issued under the book building process. Book building process. In book building, you can see people bidding and then you decide that this is the final price. I got very good bids or I didn't get very good bids. Accordingly, you will keep it decide the price. Concept clear? Yes or no? So red herring prospectus is a prospectus. It does not contain the complete details. It is issued in the book building process. It is a process to determine the final price of the security. It's a process of price discovery. Okay, and it must be filed. It must be filed with the registrar at least 3 days prior to the opening of the issue. So you have to tell the registrar that this is my RHP 3 days before I issue it to public. Then comes to your shelf prospectus. Now shelf prospectus also I want you to write it. A shelf prospectus, I'll just give you the meaning of the term. Okay, shelf prospectus is a prospectus for multiple issues. For multiple. So if the company is going to come out with multiple issues, IPOs, or you could say multiple public funding is going to be raised, multiple public shares are going to be offered at different times in the year. So what happens? I go and tell the ROC, the registrar of companies, listen, I'm filing a prospectus with you. You check it, keep it in the shelf. Keep it in the shelf with you. Because I'm not only going to go once. You get a validity period. What do you get? You get a validity period. That validity period will be max 1 year. Within that 1 year, I can make multiple issues. So I tell the ROC, listen, I'm filing this prospectus with you. I'm going to go for multiple times to the public to raise the funds. They say, okay, fine, but how will we know how many times did you go? At least that information we should have. So they say, okay, fine, I will file a form called as PAS2. Form PAS2 will be filed called as information memorandum, telling the ROC how many times you've gone. Every time you've gone, you have to file an information memorandum. So what is the benefit of shelf prospectus? Every time I don't have to get approval of ROC for going to public. I go once, I take the approval, and then I get an approval for 1 year. So a shelf prospectus is a prospectus under which a company may issue securities in one or more tranches without issuing a fresh prospectus. So once I give the prospectus, I can raise it in 3 parts, 4 parts, my wish. Okay, I will have a validity starting from the first date of offer. So moment I go once, opening of offer, from there I get 1 year time period, I can make multiple issues. Every time I go and make a issue, I have to inform the ROC in PAS2 about the details, financial position, how much I am raising, etc. This must be filed within 1 month prior to the second or the subsequent offer. So whenever I am planning to go 1 month prior, I have to file an information memorandum. Then comes abridged prospectus. We were seeing types of prospectus, and in types of prospectus we saw 2 kinds, right? Under which definition is given prospectus, section 2 subsection 70. In prospectus there were further 2 prospectus definition meanings given of 31 and 32. 31 is about shelf prospectus, that is one prospectus for multiple issues, and 32 is about red herring prospectus. A red herring prospectus is a prospectus with incomplete details. The price band is covered, and the main purpose is to make a price discovery at the price. So you want to. So these are sentences you can write. Red herring prospectus is a process to discover the price on basis of market demand. On basis of market demand, it is a price discovery process. Simple. Now there is one also prospectus type which we are going to see, which is called as red herring. Now different other types are there, like deemed prospectus and abridged prospectus. So what is a abridged? Abridged means salient features. The abridged or the highlights will be given. So it is a prospectus which contains the salient features. Okay, they are saying that whenever the people are coming to buy IPO forms, a bridge prospectus should be given. So question is that prospectus is already given, then why you need a bridge prospectus? You tell me that if I am giving you the prospectus, why I need to give you salient features also, highlights of that prospectus? Obviously, because to make it easier for the investor to make his investment decision. Not everybody will go in depth, but at least they would want to look at the highlights. So a bridge prospectus is a prospectus or a memorandum or a document containing the salient features of the prospectus. It helps the investor in his decision making process by giving him the highlights. Okay. A bridge prospectus is not required when an underwriting agreement is there. Okay. With the underwriter, they are there already. When they are not offered to public. So a bridge prospectus is given when you're going to public. Obviously, when you're not going to public, these salient features need not be given. Now coming to, so we did which kinds of prospectus? We did the section 2 subsection 70, we did 31, 32 and section 2 subsection 1. So we did shelf, red herring prospectus and we did abridged prospectus. Now there is a very important kind of prospectus also called as deemed prospectus. Sir, what do you mean by the term deemed? Law is assuming it to be a prospectus. So section 2 subsection section 25 and 28 contains two kinds of prospectus called as deemed prospectus. Here the company makes an allotment with the intention to further sell it to someone else, to the public. So here the company is making an allotment. Just remember, here the company takes initiative. Who takes initiative? Company makes the allotment with the intention to sell it to public. I'll explain. And in section 28, the shareholder is in requesting the company to offer his shares to public. Okay, let's see. So here the dominant role is of company. Here the dominant role is of the shareholder. And all of them, what they are trying to do, they are trying to offer it to public. They are trying to offer it to public. I'll explain with the help of example. You will understand this concept extremely well. First, there is a term called as OFS. Have you ever heard of the term OFS? OFS. OFS. Now, OFS is called as a offer for sale. Offer for sale. Now, what happens? Pay attention. When a company is there and they are offering their securities to public investors, okay, to the public. So company can go and come out with an IPO where they sell new shares. Okay, this is called as issue of shares. We issue new shares. So we issue new shares. For example, I want to raise 8 crores or 8,000 crores from the public. I want to raise how much? 8,000 crores from the public. So company can issue fresh shares. Company can issue fresh issue of shares, right? Or they can say, listen, that I will do 7,000 fresh issue shares. I will make a 7,000 fresh issue of shares. Balance may be my existing shareholders. Existing shareholders are there. My existing shareholders are there. They want to offer their shares to public. They want to offer their shares to public. This is called as OFS. What it is called? Existing shareholders knocking off their shares to public. So when you saw a company like Paytm, or you go to see your multiple Nykaa or your IPO, or you see any IPO which is there, maybe Lenskart IPO, what happened is the promoters not only sold fresh shares, new shares were launched, but existing shareholders shares were sold, so they get an exit from the company. The existing shareholders might want to sell off their stake, so they can sell it to public. So this is called as a OFS. Now what is happening is, law is saying, listen, I understand whenever you make a fresh issue, you issue a prospectus. What do you issue? A prospectus, as we saw, as a prospectus, right? And section 25 contains the contents to be covered in a prospectus, or the prospectus is checked in depth. They see that there is no misleading information. They see that all the important information for decision making is there. But when OFS is done, a particular document is issued, telling that, you know, the XYZ person is selling, do you want to buy? So they say that, listen, ultimately you're going to public, we want all the public to get correct information. So all rules of prospectus also apply here. With respect to misstatement of prospectus, etc. will be there. So therefore, this document by which shares of the existing shareholders are being sold to the public is going to be called as what? What it is going to be called as? It is going to be called as deemed prospectus. Why deemed? Because law is going to deem it to be a prospectus, and all the rules, liabilities, responsibilities with respect to prospectus will also apply on this document. That you shouldn't have misleading information in this document also, because we are going to protect the public. The main objective is to protect public. Concept clear? Yes or no? So OFS part I will first explain in from point of section 28. Okay, 28 is very clear to understand. Pay attention. First I'm teaching 28, then I'll teach you 25. 28 is the example that I gave you. Section 28, offer of sale by certain members. So maybe the shareholders can go to the company and tell that, listen, I have a lot of shares, please can you help me to sell it to public? Company says, okay, fine, we'll launch it, we'll make an advertisement, we'll broadcast it, we will tell everyone, we'll make a prospectus, we'll put in all the information, whatever is, and then we'll issue it. Whatever expenses is there to sell your shares, company will reimburse it, or will charge, or will deduct from the final figure to give you. Before that they will deduct. Now pay attention. Section 28. Certain members of the company may, in consultation with the board, so members may, they don't have to sell, they may, they speak to the board of directors, offer all or part of their shareholding to public in accordance with the law. So either you want to knock off all or some part of your holding, the board will help you out in selling. Now the offer document by which you make the sale to public is deemed prospectus. Any document by which the shares are offered to public shall be deemed to be a prospectus, and therefore the provisions with respect to contents of prospectus given under section 26, okay, has to be followed. Liability, civil and criminal liability has to be followed. Members shall be authorized to act on behalf, and they can reimburse the expense. All the expenses can be reimbursed. The prospectus must disclose the name of the entity bearing the cost and the reason. So anyone trying to help you to sell, all those details should be given. So this is in section 26. Just make the correction. This is your section 26. Contents of the prospectus. Now we come to deemed prospectus. Now this is a little different. Now pay attention to this. Okay. Now what is this point? What are they saying? That when the company, okay, what is happening? When a company offers a document, when it becomes a deemed prospect. Now I'll explain it with the help of an example. Then it will be clear to understand. Okay. Now what is happening is, company, if they would have gone to public, Now which section we are doing? We are doing section 25. Then obviously this document would be called as prospectus, and all the rules of prospectus will apply. Now what a company does, in order to escape the strict norms of prospectus and what all is to be given in the prospectus, company gives it to a person, and this person offers it to public. This person offers of sale to public in a very short duration. Okay, this happens. So they've given that, listen, what is happening is, when company gives it to public, prospectus and all the requirements are there, your company offers it to someone with the intention that this guy will further sell it to public. So then he will not have to follow the rules of prospectus. So law says, listen, if this happens, then this offer of sale, by whichever document you do, this will be a deemed prospectus. And all the principles, rules, requirements of a prospectus will also apply to this document. Clear? Now pay attention. And how do you determine that the company had the intention? Company intends it to offer it to public. How will you come to know? We'll see that also. They give me two categories. So now pay attention to this, okay? That a document offering the shares to the public shall be treated as prospectus if the company has allotted securities with a view to offering them to the public. So what did the company do? Company allotted the securities to someone. They didn't give it to someone. They just said the company has allotted with a view to offering it to public. Like in my example, as I told you, I offered it to someone with the intention that it will be offered to public. And any of these conditions are there. And any of this condition is there which will show me that the company had the intention. The company had the intention. How? I didn't receive the money. So the offer was made within 6 months of allotment. So then we will be presuming. So we will presume, this helps. Presume company had intention. Because I offer it to you and immediately within 6 months you offered it to public. So it is assumed that company knew that they wanted to give it to public. So company gave it to a person and that person immediately gave it to public. So that document by which he is offering it to public is a deemed prospectus. Or even a second category, they said the company has not received the full amount on the date of offer. So for example, that person has not paid us only amount. We give it to him. He is not paid me the amount. He is selling it to public, receiving it from public, and then giving it to me. So if I have here in this category, second category, is company has given it to this person and this person has not made any payment yet. No payment made. So that means, and he's offering it to public. That means public will give him and then he will give me here. So this also shows that the company has the intention or company is involved, and any offer made, that document will also be deemed prospectus. So two categories are there here in section 25. Okay, and then what happens if it is a deemed prospectus? All the legal requirements, liabilities, of a prospectus will also apply to this document. Matters to be stated in the prospectus, that the prospectus should have all material information should be there and it should not contain any misstatement. Now we are going to see share certificates. Very, very simple. Can I say that this provision is outdated now? Can I say that this provision is outdated of physical share certificate? See, what is a physical share certificate? Moment you buy a share, you get a physical share certificate. Today when I buy online shares, I don't get a share certificate. So can I say this provision is become redundant, outdated? Answer is no. Today there are so many private companies, okay, small companies, we do not have big assets or turnover. They nowadays issue physical share certificates only. So physical share certificate is a prima facie evidence to title that you are the owner of the share. Section 45. Now section 45 is that each share will have a distinctive number. We done this earlier also. Share certificate will have a distinctive number. However, it is not required for online shares or Demat shares. So just a provision, who is required to sign? Who is required to sign a share certificate? So a share certificate is signed under section 46 under the common seal by two directors or a director and a CS. So two things, and is a prima facie evidence of title. The first thing is section 46 subsection 1. It is issued under common seal, or it is signed by two directors or a director and a CS. So we can see a CS is coming as a position of a director only, two directors or director and CS, or under a common seal of the company, if any, and it is a prima facie evidence of title. So anyone whose name is mentioned is the owner of that share certificate. Now section 56 subsection 4 tells a timeline to issue the share certificates. So now physical share certificates, if it is there, it has to be issued within certain time. Now how much is the timeline? That is given under section 56 subsection 4. I'll tell you, very simple it is. So just remember 2 months, 1 month and 6 months. Okay. So the timeline to issue share certificates. Timeline to issue certificate. Clear till here? Given under which section? It is given under section 56 subsection 4. So if it is at the time to a subscriber of MOA, okay, if it is a subscriber of MOA, it should be issued within 2 months from the date of his name is entered in the MOA. Second, if it is with respect to any in writing, okay, you are transfer of shares or a from the date of incorporation or the date of allotment. So this is with respect to subscribers of MOA is within 2 months of the incorporation, and if it is allotment, so 2 months, and I can say if it is a 2 months from allotment. If you applied in writing in IPO etc. and it was within 2 months from allotment, this is 2 months from incorporation. If it is with respect to transfer or transmission, then you have 1 month, and if it is with respect to debentures are there, then it will be 6 months. Clear? Let's see, read it and finish it off. So if it is a subscriber of the MOA, it will be within 2 months from the date of incorporation. If it is with respect to allotment, then within 2 months from the date of allotment. If it is transmission, within 1 month from the receipt of instrument of transfer, and if it is with respect to debenture, 6 months. Concept clear? Timeline. So 2 months from incorporation if it is a subscriber to MOA, 2 months from allotment, 1 month from receipt of transmission form, and 6 months if it is allotment of debenture. Simple. Now coming to duplicate share certificates. Now remember share certificates. Now this also point you can write that a share certificate, okay, it is issued in SH1. In which form it is issued? SH1. Okay, and a register of duplicate share certificates, is maintained in SH2 of duplicate share certificates. To whom and how many you have issued will be in SH2. Clear? Let's start. Now, duplicate share certificates. Under section 46 subsection 2, a duplicate share certificates may be issued if the certificate is proved to be lost or destroyed, defaced or torn. So under section 46 subsection 2, a duplicate share certificates may be issued when it has been torn, it has been lost or destroyed, defaced or torn or defaced. Now in this case, so when duplicate share certificates are issued, pay attention. So duplicate share certificates are issued in two categories. What they are putting, lost or destroyed, and here it could be torn or defaced. Now my question to you, that while issuing the duplicate share certificate, where the procedural requirement will be more, you can't just issue it. You would require some procedural requirement to tell that get me this document, let me see. Where the procedure will be more, in category 1 or in category 2? See, what is happening in category 1, it is not there only, it is lost. So you don't even have any copy of it, or it is destroyed completely. So in this case, normally board resolution is taken. A board resolution is required when issuing a duplicate share certificate when it is lost or destroyed. But if it is torn or defaced, it is torn, you can see it, or it is defaced, just due to water is due to water it got spoiled, etc. So here it is BR is not required. Company secretary can directly issue it. Okay, it can issue it because it is torn and defaced. Now this depends on the articles of association and its requirement. So that is why they have grouped it in two categories. See, torn and lost and destroyed they have kept in separate category, and defaced and torn is different because it is surrendered. Here it is surrendered to the company. You can see it physically. I told you SH1 is there, and SH2 it is a register for maintaining duplicate share certificate. Now coming to the next one is a split certificate. Okay, what I'll call it as split certificate. So what is a split certificate? Now sometimes if I have bought, let's say 1 lakh shares together, I have bought 1 lakh shares together. So one share certificate will be issued. One share certificate is issued saying that I am holding physical share certificates from, see, all this doesn't happen in Demat. Okay, so it is not that important. It could come in private companies, etc. You know, that too small private companies, because even private companies now who are not small companies, as per rule 9A and 9B, have to mandatorily issue in Demat form only. Private companies which are not small, so only small companies today will be having physical share certificates. So let's say it had 1 lakh shares. So one certificate was issued saying that I am having share certificate number 1 to share certificate number this much. Now I want to sell half of it. Now how will I sell half? So first I have to apply to the company. I have to apply to the company to split it. That give me 75,000 share certificate 1 and 25,000 share certificate this, and then I can sell it separately. I can sell a part of it, etc. So a split certificate is basically a new share certificate of a portion of the existing certificate of the existing shares. So then two will be issued. A split share certificate is issued for a portion of the existing shares without changing the total number of shares held. So total number of shares, still you have 1 lakh, but a certificate is issued to split the holdings in different share certificates. Done. So you can then transfer it, or maybe mortgage a certain part, etc. treated differently. Now we are coming to difference between original and duplicate share certificates. Just the rule numbers are there. This is rule 4, 5 and this is rule 6 for duplicate. Okay, it is issued on allotment, and this is include when you surrender your old ones. Timeline is given. Register, I told you, SH2. That's it. Okay. Now from here, let's see if any important case laws are there. So all you need to read, okay, all you need to read, but I'll just, tell you some important ones. Prima facie evidence of title. A share certificate is a prima facie evidence of title as given in this case law. So this is obvious. Okay, so it's very rare that they will ask you, but you can quote it proactively in the examination. Estoppel as to payment. Now estoppel means the word stop is there. So nobody, if a share certificate has been issued and it has been fully paid, then nobody can stop any everyone will be stopped from disputing this fact what is being given in the share certificate. So that means if in the share certificate has been written that Mr. A is the owner and he has paid the full money, so then everyone, the company is stopped from disputing the fact that is stated in the certificate. One very important point which they have asked in the exam also, it's through a DCA circular. Earlier it was called as Department of Corporate Affairs. Circular was there. In that they said that, listen, when a share certificate has been issued, is it an official publication? Is it an official publication? So is a share certificate an official publication? So the answer is no. A official publication could be a share certificate, could be a newspaper advertisement, could be a prospectus, but not a share certificate. So a share certificate is not an official publication. Official publication means to the world. No, it is just to the person. Is a certificate of title and movable property, but not an official publication. As a prospectus, balance sheet, etc., it is issued to the world. Estoppel, very simple, that two kinds of estoppel are there. Estoppel means the company will be estopped or the world will be estopped, that is disputing two facts with respect to title and with respect to the payment. So no person can dispute a fact that a person is not the owner or the person has not made the payment if the share certificate is saying that. Very simple. Now, impersonation of shareholder. Personation of shareholder. Not important, just read. Personation means what? It is that if anyone pretends to be XYZ and takes the shares fraudulently, then penal provisions will be there. So if you try to impersonate, for example, there is a person and his twin brother has gone and tried to take the share. So he is deceitfully impersonating and acting as the owner and trying to get any rights, then there will be fraudulent. So anyone tries to pretend to be someone else, then they will have penal provision. So with this we've completed your second part of the chapter. Thank you. Okay. Till here, clear yes or no? I want everyone in the chat box to say clear yes or no. Then I will start with part C, D, E, and then done. Your entire chapter will get done. And I'm covering everything, okay? Every important thing I'm covering. So I want you all in the chat box, clear in the chat box. I want everyone clear in the chat box. Clear in the chat box, quickly. And don't forget to like the video also. Okay, so we will waiting. Kim, Sona, great. Let me know about others also. Sir, could you please provide the chapter wise weightage for company law that you've given for GIGL? Shri, remember that I have given a just put a chapter wise weightage for CS executive on YouTube. My video will come first. There I have given latest full this has been given. Okay, the chapter wise weightage has been given. Clear? So we will resume part C in maybe in 3 minutes, 2 3 minutes. We'll just take a breather and we will start and complete this time. Till then, I will take a breather, but now you have to go and complete your part B. See if there's anything left out. Note down everything and let me know. So we can say here. Then I will start with part C. Till that, your job is to revise part B and Q. Hi guys, am I audible and visible to you all? Please let me know in the chat box so we can quickly start. Okay. So am I audible and visible? Yes or no? So we can quickly start and complete this part. Okay, great. So we will be starting with the part C and completing this as well. Okay. Till that, I just need your confirmation in the chat box if I'm audible and visible. So we will be starting with part C, that is issue and allotment of securities, and part D. So I could say from this chapter, part C and part D are the most important. Okay, and obviously you must have seen that the past exam questions are being framed from here only. So I will be teaching you techniques to even memorize all of this, and you do this, whatever I'm telling you, that is more than enough. So before I start, I need a confirmation from you all. Yeah, okay. Great. Shri Lakshmi, great. Great to have you. Okay, let's begin. And Shri Lakshmi, do share it with your friends as well. I think this is the first time you are attending the lectures. Okay, and all the students from South India, please do share it in your WhatsApp community as well. All your study groups, because very few lectures are there in English who are genuinely taking lectures. Okay, of educational where they are, covering all these topics for you. So, and many students are unaware, and it just, I leave it up to you to share it and put that word out for your friends as well. Okay, so let's begin. Hi, so we'll be starting with the part C, that is your issue and allotment of security. Now, this is one of the most important parts of your entire chapter. Now, part C talks about issue and allotment of securities. Let's see. So first thing is your chapter 3 of Companies Act. Okay, so when you go to your chapter 3 of Companies Act, that is about chapter 3 that talks about your prospectus and allotment of securities. Prospectus and allotment of security, that is part 1, which talks about public offer, and part 2 talks about private place. Part 1 talks about section 23 to 41, and private placement is covered under section 42. So, prospectus and allotment of securities. The first part is from section 23 to 42, which talks about public offer. So when you want to go, so a prospectus will be issued, right? Here a prospectus is issued. Once a prospectus is issued, I'm allowed to go to the public. Okay. And in a private placement, they have a placement memorandum, or you could call it as a offer letter, where to whom you want to allot, because it's not offered to public, it is given to a selected group of person. Company in advance knows to whom they are giving, they give an offer to them and they ask whether you are investing or no. Okay, let's see. Section 23, okay, section 23 states that a public company can make what kind of issues. So very simple, not very important, but very easy to understand. A public company can come out, okay, they can make a private placement if they want, but they can also go for right issue, bonus issue, and they can even offer it to public. So a public company can come out with a public issue. They can come out with a private placement. Public company has more powers. They can issue to public, or they can give it to a selected group of person, or they can give it to right issue. What is it? We will see later, and even bonus issue. From here, I will tell you that only one change is there, that what happens in a private company. Private company can make a right issue that is given to existing shareholders. Private company can give free of cost shares also, which is called as bonus shares. Private company can do a private placement also, but private company cannot make a public issue. Very simple, that is given in the next subsection. That is your section your section 23 subsection. What does it say? A private company may issue by right issue bonus shares and private placement. They cannot come out with a public issue. Common sense. Now we look at the types of issues, the different kinds of issues. So here they are going to talk about issuing of shares at premium and discount. So this order of sections I will teach you in a very simple way. So your section 52, 53, 54. Very simple. Okay, and even 55 you've done, I'll tell you. Section 52 is issue of shares at premium. Okay. Here section 53 is about issue of shares at discount. Third, this talks about sweat equity of shares, sweat equity, which is also repeatedly asked exam question. And this talks about preference shares. Preference, very simple. So if I want to issue shares at premium, that is, if the face value is 10, I can issue it at 12. The 2 rupees is your premium amount. That premium amount goes in a separate account called as security premium account. And that security premium account can be used only for very specific cases which they have given, which is also very important. Now I can issue shares at premium, but there is a prohibition to issue shares at discount. In India, shares cannot be issued at discount. Only one exception is there when you are issuing sweat equity, that is given to an existing shareholder. Let's see and complete the provisions. So very simple, what do you mean by issue of shares at premium? So when you are issuing above the nominal or the face value. Section 52 subsection 1 states that you are allowed to issue shares at premium. Okay. But that premium amount goes into a separate account called as security premium account. So if I am issuing shares at premium, then the premium amount that is there of 2 rupees, if I am issuing at 2 rupees premium, that 2 rupees goes in a separate account called as a security premium account. And this security premium account can be utilized only for, and this they ask in exams. They will give you a situation, can it be used here, can it be used there, can it be used here? So the answer is you have to know what all it is there. First is bonus shares. It can be issued to, because see, bonus shares, it is issued free of cost to the shareholders, but from someone has to pay for those shares. So we can use the security premium account. Okay. Any preliminary expenses, pre-incorporation expenses can be used. This premium account can be used to pay past expenses. If we are issuing writing of commission or discount on issue of debentures, so if there is any commission on shares, see, shares can't be issued at discount, but commission is there, any kind of flotation cost. Flotation cost is basically while issuing a lot of commissions need to be paid, underwriting commission, etc. So that can be used. Discount, debentures can be issued at discount. Shares cannot be issued at discount. So all of that we can use it from the security premium account. Premium payable on redemption of preference shares. So whenever redeeming preference shares, we can use this money or debenture. So the premium payable. So this premium account can be used to pay the premium on debentures and preference shares. And buyback. Purchase of its own shares is called as buyback. So just remember that you can use this security premium account. Very important. It's asked in the exam multiple times because students can forget all these things, right? Under section 2 subsection 52 subsection 2. So let's see what all points are being given. If it is bonus shares, if it is preliminary expenses, if it is issued at a commission that you're paying, any premium on debentures or preference shares, and buyback. So this is the only categories where you can use. However, when you read subsection 3, they tell that few more points have been given, that this also it can be used. So subsection 3 gives you additional permissions if you are following the accounting standards. So for companies following the prescribed accounting standards under section 133 of the Companies Act, which is that you have to comply with the accounting standards, which obviously they will be following it. So they can use it for more things. Unissued bonus shares, paying up unissued bonus shares, bonus, writing of expenses and commission on equity, and purchase of its own shares. So it has been clubbed above. Okay, so ultimately, collectively, I have given you all the entire list. Premium, so for example, can the premium amount be used to pay dividend? So the premium is not a profit, it cannot be used for dividend distribution. Very, very important point to remember. Premium account is kept in a separate account called a security premium account. Premium account is a capital reserve, not a free reserve. Sir, what do you mean by free reserve? Free reserves can be used for distribution of dividend. This is a reserve received from capital issue. So it will be kept in capital reserve account or capital reserve. It is a capital reserve, not a free reserves. Free reserves can be used anywhere. This can't be used anywhere. It has restricted use, as I have explained to you. So section 52 is over. Now coming to section 53. Okay. What is section 53? It talks about prohibition on issue of shares at discount. So company cannot issue shares at issue of discount. If it does, it is void. However, there are certain exceptions. So can a company issue shares at discount? Answer is no. Can the company issue debentures at discount? Answer is yes, because this is for specifically issue of shares. There are exceptions. Okay. Now the exception where the company can issue a discount. So if the company has a resolution plan with which they have agreed to pay to the shares may be issued at discount to the creditors when it is through a resolution plan or a debt restructuring that has happened. So then creditors can be issued at discount if it is pursuant to any loan restructuring or any resolution plan in IBC. Again, we can issue equity shares at discount, okay, to the creditors. So only category it is there is who is to the creditors. And why? Because we had made some kind of a compromise that listen, let's please adjust. So then we are issuing it at discount. So then it is allowed. Now coming to the concept of allotment of securities. Very important. Let's see. Now section 39 read with rule 12 of the PAS rules 2014. So what are we seeing? We are seeing section 39 read with rule, okay, that is issue of that we are making allotment. So people will apply, and in application if you are successful, then the shares will be allotted to you, means given in your name. Simple. Now companies can allot, okay, allot the securities to public if the minimum subscription has been received. Now there are some rules for allotment. Now before allotment, you have to ensure that the company has received the minimum subscription. Minimum subscription is generally 90% of the issue portion. For example, if I've issued 1 lakh securities, 90,000 at least should have been subscribed by the public. And very important that the minimum application money that I am taking shall not be less than 5% of the face value or nominal value of the security. Nominal and face value is the same. So for example, if the share is of 10 rupees, if the face value of the share is 10 rupees, minimum how much I should take on application? How much I should take minimum on application? So remember, it is not 50%. Don't say 5 rupees. It is 5% of face value. Okay, so 10% of 10 rupees is 1. So it is 0.5 paisa. Okay, so remember that minimum 5% of the face value needs to be taken on application money. Whenever the company has made the allotment, a form will be filed called as PAS 3 form. It is the most important form in your entire prospectus and allotment of securities, and you should know what it is, sir. It is about return of allotment. So return means details of allotment. Return of allotment they say, but what is the meaning of return? It means details of allotment has to be given within 30 days of the allotment. Simple. Now, case laws are important, but let me take you through the important ones. Okay. Now, first important case law is Sri Gopal Chalan versus Calcutta Stock Exchange. Now, what did they say? That company had issued certain shares. The person could not pay the call money, so his shares were forfeited. So, when these forfeited shares were reissued, is it a allotment? So, the answer, it is not a allotment, it is a transfer of shares. Because what happens is allotment happens once. Allotment is like the birth of the share. Birth of a share, that is the first time when the company issues it. They issued it to you, you did not pay the call money, so your shares they've given it to someone else. So this is not a allotment, this will be called as transfer of shares. So reissue of forfeited shares is not a allotment, it is a transfer of shares. Simple. Now, general principles of allotment of securities, pay attention. That allotment means from the unappropriated part, the board of directors have decided, let's, this much we have not issued, let's issue it to that person, called as allotment. Now, what are the principles of allotment? Very important, that it should be by the proper authority, and the proper authority is board of directors. Means the BOD will issue and allot it. It must be done within reasonable time. Reasonable has not been given, but if we see allotment of shares must occur within 3 months from the. So basically the issue of share certificates, they say, should be done within 2 months. So normally what are they saying? That allotment of securities, that is share certificates issue, must happen within 2 months of allotment. This was a timeline. So first thing is BOD should do. Allotment should be within a reasonable time. It must be absolute and unconditional. Must be on the exact terms. It shouldn't be on do this, do that. So unconditional, obviously, just the condition will be you pay the money and then we'll give you the it has been allotted. Communication of allotment, it must be made. Allotment must be communicated to the applicant. Posting of a letter constitutes a valid communication even if it is lost in transit. So if the company has allotted to you and we have posted it, but it got lost in transit, still it is considered as a deemed communication. Allotment against an application. So a person becomes a member only when he agrees in writing. Thus allotment cannot be made without a written application. So never will you see that it has been allotted on oral application, oral ways. Okay, so just they have orally told you that I want to buy and I cannot allot it. It has to be through a writing. Some IPO form has to be filled, or any kind of MOA has to. The writing is involved, and allotment must not be in contravention of the law. So very basic points have been given, that it should not be in contravention of any law. It must be against a written application. Communication is to be made to the other party. If the company has made the efforts of communication, it is allowed. Allotment must be absolute and unconditional, must be within reasonable time and by the BOD. So these are the general basic principles of allotment. Then we come to very important aspect, okay, one of the most important, that is issue of shares through private placement. Extremely important. Okay, so as we saw, section 23 to 41 is about public issue, and section 42 is about private placement. So let's see what are the rules. And private placement is one of the most important even in practical life, because private companies make a private placement and then company secretaries and professionals will do all the form filing. So let's read the rules. Very, very simple. So first thing is section 42, rule 14. Rule 14 of the PAS rules 2014 talks about private placement. First, let's talk about the meaning of private placement. Private placement means when company issues securities to a selected group of person where company knows in advance to whom they are issuing. It is called as private placement. Okay. So what is it? It is issued to a offer is made to a selected group of persons. Now, how many persons can you make? Maybe I can make it at 1, 2, 3. What is the upper limit? Now, this they have asked in the exam. Okay. Multiple times section 42 has been asked in the exam. So, the max I can issue is max 200 in a year, and excluding two people, QIBs and employees. Means in section 42, when you read the Bear law, they say that the maximum 50, however, rules can increase the number. So in rule number 14, they have increased the number. They have said that a private placement can be made maximum to 200 persons in a year. Maximum to 200 persons, and that too in a year. Any issue made to more than 200 persons in a year is deemed to be a public issue, and public rules has to be followed. And this, while calculating the number 200, two categories are to be excluded. Means I don't have to count them. QIBs, that is qualified institutional buyers, maybe like a buyer who's an institution like mutual funds, I have to ignore them. Or employees, they also have to be. Now for public issue, we issue a prospectus, okay, which goes to the public. But here you don't issue a prospectus. Here you issue something called as a PAS 4. PAS 4, which is private placement come offer. It's a offer letter. Will be in PAS 4. Serially numbered and addressed to each identified person. So it will be written that, we are offering it to first this one, 2, 3, 4, all the numbers will be given. So in PAS 4, so remember, in private placement, 3 PAS forms will be used. 3 PAS forms will be used. Prospectus and allotment of securities, 3, 4, 5. 3 is a register. 3 is a what? A register of private placement. A register of private placement. 4 is what? And this is a return details of allotment. Return of allotment. So whenever we allot it to anyone, PAS 3 is always, it's a general form. Whenever allotment is made to whoever, PAS 3 is to be filed. That is the details of allotment. And PAS 4 we saw is the offer letter. The offer that we have made in private placement. In private placement. So in exam they ask that which is the form number in which you will make a offer to the selected group of persons. So it's PAS 4. Mode of payment. Now obviously when they will make a payment, the private placement is being made, then they can pay in any mode, banking route, check, everything is allowed but not cash. Okay, so this also they have asked that someone wanted to pay cash. Is it allowed? So cash is not allowed. Obviously banking route, check, demand draft, any other route is allowed. So the investor wants to pay us, he can pay us any route but not cash. And when they are paying also, they will pay in a certain specific bank account, or separate bank account must be made in a scheduled bank. That means, for example, if I've identified an investor, I go to that investor, I offer him the security, he's ready to invest. So I have to open a new bank account. Okay, and that money will come in a new bank account. Time of allotment. Within how much time I have to allot it? So obviously, once I've received the money, receive the application money, within 60 days from receiving the application money, it has to be allotted. Okay, if allotment is not covered within, we couldn't give it in 60 days, then we have to refund the money in the next 15 days with interest at the rate 12%. In private placement, public issue is not allowed. PAS 3 has to be filed within 15 days of allotment. Now very, very important, in how much time? Now PAS 3 has to be filed within 15 days of allotment. And the thing is, this is such an important section that even the penalty is important. Why? Because you see that if any of these timelines are not followed, you get a penalty which will be up to 2 crore rupees and refund all the money with interest. So obviously timelines such as pass 3 in 15 days has to be done. Your allotment has to be made within 60 days of receipt of the money. Separate bank account has to be made, and pass 4. That is it. Okay. Then I told about DVRs, very simple. Section 43, read with rule 4. What is it? This you should know. This is also a past exam question. It's also a past exam question. That is your section 43. Section 43, read with rule 4 of share capital and debenture rules 2014. Very, very important, with the rule number. So DVR, as I told you, a company wants, they can issue shares with differential voting right. It will be a different class where on these shares, one share can have 10 votes. One share, 10 votes. That is also allowed. See, I can issue a share called as one share, 10 votes. So it has differential voting rights. This is also DVR because it is not one share, one vote. One share, one vote is ordinary shares. Anything other than that is a DVR. Even it can be one share, 0.5 votes. Even this is also there. I can issue something like this also. One share, 0.5 votes. If you go to see, Tata Motors has issued one share with less than 1 vote. That also company can issue. Okay. So if anyone is interested, they can buy. Now why will someone buy with disadvantage or give an advantage to someone else? The answer is for strategic reasons. If you don't want to participate in decision making and you are more wanting to give the rights to someone who is a promoter, who you trust, like I would trust Ratan Tata running Tatas, I would trust Mukesh Ambani running Reliance, I would trust Mark Zuckerberg running Facebook, Steve Jobs running Apple. So I will give them extra voting rights also. I will take less voting rights. That is also the logic. Now here we are not going into why DVRs should be issued. I am talking about if a company wants to issue a DVR, how I can do it. So first, very simple, article should authorize. What it is? AOA should authorize, ordinary resolution should be done, max DVRs that can be issued is 74%. Means every share cannot be DVR. The voting power with DVRs must not exceed 74% of the total voting power. Means I cannot have everything DVRs. The maximum voting power with DVR should not exceed 74%. So up till 74 DVRs can be issued. Cannot exceed 74%. Means I can have all the DVRs which are having up till 74%, not beyond that. In respect of all the shares with DVRs must not exceed 74%. No filing. Now, what is the condition? Till now we have seen rules is basic ordinary resolution. They should not exceed this limit. And most important, no default. So no default in multiple things. No default in financial statements or annual returns in the preceding 3 financial years. Now this is also very important. In the preceding 3 financial years, no annual return or financial statement filing default. Should not have defaulted in any dividend, deposit, payment of preference shares, debentures, interest thereon. No default in the crediting the amount to IPF. Okay, no penalty, regulatory penalties. Must not have converted existing shares into DVRs. Now this is also very important, that now this they can ask you in the exam. Okay, what they'll ask, the company must not convert its existing ordinary shares into DVRs and vice versa. A separate class has to be issued. You cannot convert ordinary into DVR and DVR into ordinary. Very important. This also they can ask in the exam. Then so these are the law. This is the law that you have to keep in mind. Okay. Then a proper recording in register of members. So register of members should have that, these are the persons who are having differential voting rights. in apart from the voting rights, they will be same in all aspects. Means they can also attend the board meeting, they can also attend the general meeting. They are entitled to bonus issue, right issue, everything just like everything else, everyone else. Okay, they enjoy all other privileges same as others. Only in voting rights the difference is there, right? And all disclosures must be made, and disclosure must be filed in the board report also. Board report is attached to the annual report which is given to the shareholders. In that they write under section 134 subsection 3, which talks about board report. They write that DVRs have been issued, to whom they have issued, and what is the intended purpose. Clear till here? So we are done with section. Which was the section of DVRs? DVR is under section 50, under 43 rule 4. Okay, 43 rule 4. Now again, very simple, issue of preference shares. Now we are looking at issue of preference shares. Now you have to remember the section 55 rule 9. Very simple. If you want to issue preference shares, take a special resolution. Article should authorize, and that it cannot be irredeemable, and redeemable also 20 and 30 years. You have to keep in mind. That's it. Done. So maximum 20 years, except for infrastructure, you get 30 years. Articles of association, special resolution, no default should be subsisting, and redemption can be made only out of profits or proceeds of a fresh issue. The company can redeem shares only if they are fully paid up. So redemption, only if you are fully paid up, then only the redemption can happen. When redemption is out of profits, the company must transfer an equivalent amount of nominal value of the shares to CRR. Means if I am removing, I'm paying this from the CRR, then a certain amount again has to be refilled. So refill the CRR. Where redemption is out of profits, the company must transfer a certain amount to CRR. Now, if a company is unable to redeem, okay, they are just talking about rollover. Rollover means what? If the company for some reason is unable to repay everyone, then they can take a consent of 75%. And listen, for some reason I cannot complete it on the redemption date. Please give me more time. So anyone, I'll have to take the approval of NCLT, consent of all the shareholders, and those who are not agreeing, I'll have to repay them. So this was the overall part that you can remember. Now coming to something which is most important, that is section further issue of capital. Market is important. Further issue of capital, section 62 subsection 1. Now subsection 1a b c, subsection 1a b, that is ESOPs and preferential amount is right. Now we are going to see further issue of the right issue when we give it to existing shareholders. When we give it to whom? To right issue means when the company issues it to existing shareholders. See, this is also called in business terms called as cross selling. If I have got my customers, I have already got shareholders who have already paid me the money. I decide that listen, I have already paid you, and I paid you the money. Now I want to issue fresh, I want to raise more funds. So I'll give you my new shares at discount to my existing person. So that is called as right issue. ESOPs is when I give it to employees. And this is like private placement and very similar to private placement. Here I give it to certain selected group of persons. This is mostly, the rules are connected with listed company, are more connected with preferential allotment. Okay, and very minor changes are from private placement. Let's see in depth. Now the first one that we are doing, now we are going to see each one in depth. So the first thing is right issue. Section 62(1)(a) read with Rule 12(a). Rule 12(a). What is right issue? Right issue is an offering securities the existing shareholders of the company in proportion to their shareholding through an offer letter. Means what? If I want to issue, let's say you have 10%, someone else has 12%, some other person has 1% of the company. When the company wants to issue 1 lakh shares, one person comes and says, I'll buy the full 1 lakh. They say, no, the same rights to buy at discounted prices will be in proportion to your shareholding. For how much shareholding you have? So you will say, I have 10% shareholding. So I say the number of shares that I'm offering at discount, you will have a 10% right over it. So from your 10% you can buy at discount. Someone else has 30% shares in the company. So I will say, come here, since you have more stake, the benefits also you will get that much benefits. If someone has only 1%, so I say from here you will have 1% rights, the 1% is this much shares, you can buy this much at discount. Right? Let's go back. Conditions. Conditions for issue. Offering shares to existing shareholders. So offer must be made only to the existing shareholders in proportion to the paid up capital of the company. Notice. Now obviously I have to give them a notice through offer letter. The company must issue a notice specifying the number of shares offered on basis of the shareholding, and the time period will be 15 to 30 days to accept it unless a shorter notice has been approved. So normally offer letter is given between 15 to 30 days. However, company can accept it, can pass a prior thing to reduce this 15 days time to 7 days. Let me explain. Here I tell the shareholders that listen, I am ready to sell my certain shares at discount. You are entitled as per your proportion to 300 shares at discount. Do you want to buy at discount 300 shares? So you'll say, I'll go ask my parents and come. So we will say, listen, you go, you ask whoever you want, financial advisor, whoever it is. The offer period offer is valid for minimum 15, maximum 30. Through an amendment, this 15 days can be, they have told, this 15 days can be reduced to 7 days also if a shorter notice has been approved. Now, right of renunciation. Imagine if someone comes and says, no, I don't want, you're giving me 300 shares at discount, but I don't want to buy even one, I don't have any money. So you have a right to renunciate, give up your rights or transfer to someone else. So shareholder has a right to renunciate. Renunciate means what? Either you give up your rights or transfer it to someone else. You tell someone else in the market, listen, I'm getting this shares at discount. You give me some benefit, you take that benefit. You take these shares in favor of dispatch of the letter of office. The letter of office must be dispatched at least 3 days before the issue opening date through registered post, courier or electronic means. Okay, the shares not accepted, then the board will dispose of the shares in a way which is not disadvantageous to the company. Means if there are some shares which are not taken up by the existing shareholders, then these shares the board of directors will decide what to do, and this should not be something which puts a company at a disadvantage. Means work it in the interest of the company. Then comes issue of shares at preference. Now we did issue of shares at right issue. Now we are doing existing on preferential issue. Section 62(1)(c). Okay, 1B was ESOPs. Now preferential, when we are giving it to selected group of persons, it is based on special resolution and valuation. Very similar to private placement, and you will see they are saying even the rules of private placement are to be followed. Only minor changes will be there, I'll tell you. Article should be authorizing, you require special resolution. Here, this is the new thing which is not there in section 42. That a valuation report is needed here. Okay. Detailed explanatory statement. Again, one more important thing. So if you are going under 62(1)(c), then you have to comply with these conditions. The preferential allotment must be completed within 12 months of passing a special resolution. All this is very similar to SEBI listing. When you see, I read SEBI laws with respect to SEBI ICDR regulation, you will see that this is very much, they use the word preferential allotment, and all these timelines are also very same. So this is mostly for listed companies. Now, non-cash, where securities are offered for non-cash considerations. For example, someone giving intellectual property, then the valuation certificate must tell that by what intellectual property is coming, whether it is a form of an asset or we should treat it as a expense that we are paying. Pricing of convertible securities, if we are issuing debentures under private placement, then if convertible securities are issued, then the company must fix the conversion price upfront or within 30 days of entitlement based on fresh issue. So if, just remember that for convertible issue, the company must fix the conversion price upfront. Means what? If I am issuing convertible debentures, so at what price it will convert, that also has to be given. Then comes ESOP. What is ESOP? Employee stock option schemes under section 62(1)(b) read with rule 12. So ESOPs is basically when you give it to employees. What all condition? Now all these three you see, you will see that special resolution is needed. So you'll write that article should authorize or approval of shareholders is required to special resolution. Here ESOPs will be given to eligible employees. You will want to give stock options, shareholders some stocks, shares, only those who are performers. So you have to identify, a compensation committee is made. A compensation committee basically is a committee that will look at who are the eligible employees, who are the talented employees to whom the ESOP need to be given. Now the objective of issuing ESOP is to make them stay in the company for long. So for example, if you go to see, many times good talented employees are given stock options, ESOPs. So let's say if I give the option to you that listen, you can buy these shares at discount and it will have a lock-in period. So the lock-in period will be minimum 1 year. So there will be lock-in period. Okay. Lock-in period will be there of 1 year. Means what? Moment I give it to you, at least you have to be with the company for 1 year. That time period can be increased but cannot be less. I grant it to you and it will vest after 1 year, after 2 years, after 3 years, after 5 years. So if I give you some options and I say that listen, you have to work with the company for 2 years and only then it will vest. Okay. So minimum is 1 year. This cannot be transferred, non-transferability. So obviously I am giving it to the employee, talented employee. He cannot transfer this right to anyone else. No voting rights or dividend till it is not vested in him. Till that time period is not over, no, he doesn't get any rights. He can either decide to, wait and work for the company, or he can lapse it, or if he does not complete the entire lock-in period and in between he leaves the company, then those shares will be forfeited. If there is death or disability, then that lock-in period will not apply and it will vest immediately in his legal heirs. A separate register will be maintained of ESOPs in SH6. So what are the points of ESOPs? Special resolution given to selected group of persons, 1 year lock-in period is there, cannot transfer it to someone else, no dividend or voting rights till it is vested in him, then it will be forfeited if he leaves the company before the lock-in period is over. Only if there is death and disability, lock-in period will not apply, it will vest immediately, and a register will be maintained of ESOPs in SH6. So we did section 62. What did we do? We did section 62, subsection 1, subclause A, B, C. Clear till here? What was subsection 1? Right issue. Right issue is given to existing shareholders. Subclause B is given ESOPs to employees, and preferential allotment preferential allotment is given to selected group of. Simple. Now we come to bonus issue. Now bonus issue is given under section 63, the next section 62. After 62 is 63. Bonus issue. Bonus issue also requires special resolution. It is basically issuing, it is called as capitalization of reserve. What it is called? It is called as capitalization. You see, normally in layman terms, what do you mean by the term bonus? Issuing free of cost. But in law, we don't say issue of free of cost. What do we say? That if you go to see, your company is issuing shares to you free of cost. Means we are not taking any money from you. Someone is paying now. So what happens is, share capital, let's say share capital of the company will go up because all the shareholders are given bonus shares. Share capital will go up, but they never paid the money, but still the capital of them they will have now. So who is paying for it? So the reserves are deducted and it is transferred to capital. That is why it is called as capital, right? Capitalization of reserves means the money from the reserves is appropriated or adjusted into the capital. Means company has deducted the reserves. Company paid for you, someone paid for you, you didn't pay any money, but company removed it from the reserves. Concept clear and very simple. Article should authorize same points. Special resolution is needed. Okay, must be approved in the general meeting. Yeah, for bonus shares they have said it should be approved in the general meeting, and company should not have defaulted. No default in payment. Now imagine I'm distributing bonus and I'm making defaults. Law will say that listen, first to rectify all the defaults, when if you are under default you cannot give bonus shares. Partly paid shares must be fully paid shares before the bonus shares is given. So bonus shares cannot be given, okay, if there are partly paid shares. All the partly paid shares have to first be made fully paid shares, then we will issue bonus. So bonus is given on fully paid shares. One very important point you have to remember, that bonus is called as stock dividend. Okay, now pay attention. Dividend could be of two kinds. Dividend could be of two kinds. One is called as stock dividend, and they could call as cash dividend. Now cash dividend is actually given under section 123 to 127, which is actual dividend, that is the full money is given. That is called as cash dividend. In stock dividend, money is not given, shares are given. So it is covered under section 63, which is called as bonus shares. Now these two are two different sections. So if the company has promised you, cash dividend, they cannot give you stock dividend, and if they promised you stock dividend, they cannot be giving you cash dividend. Means if I have told you I'll give you cash dividend, so I have to give you cash dividend. If I have told you I have to give bonus shares, so I have to give you bonus shares. So company cannot issue bonus shares in place of dividend, in lieu of dividend. Very simple. Instead of dividend I cannot give you bonus shares. It's two different things. From where will you get this money? Very, very important to issue bonus shares. So as I told you, the biggest source is free reserves. But if you even read section 52 and subsection 2, which talks about security premium account, it can be used to give bonus shares. Even capital redemption reserve can be used. But we cannot use revaluation reserve, where we just revalued the building. We said earlier it was 2 crores, now it is 3 crores. Now you didn't get real money. So these are all real money that we have got. Clear? So bonus shares is covered under section 63. Authorization of articles, it must be approved in the general meeting. Company must not be any default. Fully paid shares should be there. It cannot be lieu of dividend, and the sources has been given from where this can be given. Most common is free reserves, but other security premium can also be used. So bonus shares are same as stock dividend. Concept clear? Yes or no? Bonus shares. Coming to the next important and very repeatedly asked exam question. It is your sweat equity shares. What is it? Sweat equity. Now, sweat equity is given under section 54, rule 8, and the definition of sweat equity is given under section 2, subsection 88. It gives you definition of sweat equity. Let me explain what is the meaning of sweat equity. So it is basically the company, normally if there is any person, company would have issued shares, they would have issued equity shares to any person. In return, what this person would have given? Cash. Here he is not giving cash, he is giving cash equivalent, maybe some value addition. He is giving in return intellectual property rights, IPR, in return. So what is this? It is issue of equity shares by the company to a person. Now this person would be ideally an employee. Why? For making available certain intellectual property rights or value additions, by whatever name called. So what are they saying? That this employee must have given his know-how, some software that he must have made, some rights, technology rights that he must be having, which he has made, and that he is giving in the name of the company. So in return, company is issuing equity shares to him. So very simple. You, from one hand, you give equity shares. In return, what do you get? Some value addition or some benefit, but not cash. Okay. So what all provisions are there? Let's read. Very important from exam point of view. Okay. So market as super important. It is super important. Okay. Now we will see. Introduction. So what is this? It is equity shares that are equity shares issued to employees and directors at a discount for consideration, for a non-cash consideration, in return of IPR or value addition. Which resolution? Almost all the issues require special resolution. Special resolution authorizing this remains valid for 12 months for making the allotment. So moment special resolution has been taken, within 12 months you have to make the allotment. So once a special resolution has been made that this employee has given this intellectual property rights, against him we are going to issue equity shares. So this allotment in reality should be completed within 12 months. Now the equity share, the sweat equity, will have a lock-in for 3 years. Now as we saw ESOPs, here also you are going to have a lock-in period. Sir, why a lock-in period? Obviously we want this talented employee to stay with the company. That is why sweat equity is issued. Limit on the issue, very important. Okay, this is some threshold that you need to know. That a company cannot issue more than 25% of the paid up equity capital or shares worth 5 crores, whichever is higher. So company cannot issue, okay, 5% of paid up equity capital or rupees 5 crores, whichever is higher, in sweat equity. Means I am giving equity shares. They are giving an upper limit of how much equity shares I can give. Max, so max sweat equity I can issue is 15% of the paid up equity capital or 5 crores, whichever is higher. This is the upper limit. And now I give it in this year, next year. They say no, this is in 1 year, right? And the overall, this is in 1 year, overall 25% of paid up capital. So this is in a year. I can issue max 15% of the paid up equity capital of 5 crores, whichever is higher. In entire life of the company, more than 25% of paid up capital is not allowed. This, any non-cash consideration, okay? So now valuation of non-cash consideration. Any non-cash consideration will be valued by a registered valuer. So a registered valuer under section 247 of the Companies Act, who's a proper valuer. He will value that you have issued so many equity shares, and he will value the intellectual property. What is he giving? How valuable it is in the market, etc. That will be studied. Then a register. Company must maintain a register of sweat equity in form SH3. Register of sweat equity will be in SH3. If it is issued to a director or manager, the value of the sweat equity is treated as managerial remuneration. So it is treated that he gets there is an upper limit that managers can get a remuneration. Beyond that, they require some additional compliance. So this benefit will be counted in their managerial consideration. If it is issued for non-cash consideration, not forming an asset. Okay, if it is forming an asset, it won't be counted in their managerial remuneration. But if the chartered accountant finds that this is a proper asset, intellectual property rights which is given, software is an asset which will come in the balance sheet asset side, then it will not be treated as managerial remuneration. If they realize that it is not big enough to put in an asset side, it is just an expense that we should count, then it will come in the managerial remuneration. With this, we have completed our part C of the entire chapter, which is also the most important. Thank you. Is it clear till here? Yes or no? Okay. Is this clear? Yes or no, everyone? Then I will start with part D. I will be starting with part D and I will also complete it. Okay. I will be starting with part D, that is alteration of share capital. So this also I'll complete it for you. Give me 5 minutes break and we will resume it. Okay, we'll complete the entire chapter today. Okay, so we will resume by, it's 8:44, so we resume in 5 minutes. And then we will resume, okay? Hi, so we'll be starting. Hi, so we'll be continuing and completing the chapter in one go now. So the last two parts are there. Just let me know in the chat box if I'm audible and visible. I'll complete this full chapter for you. Just let me know in the chat box if I'm audible and visible. Yeah. In the chat box, just can I have GTG in the chat box? So I know I'm audible and visible. Can I have GTG in the chat box so I know whether I'm audible and visible? If you can hear me and see my screen clearly, just let me know GTG is good to go and we will start. Okay, so let's begin. Again, waiting for your consent 1 second. Okay, so wonder. Okay, thank you so much, Sia. Great. Let's complete this chapter. Hi, so we'll be starting with part D, that is the alteration of share capital. Now let me tell you, alteration of share capital is under section 61 and it is to be read with section 61 and section 64. Now let's understand what is the meaning of the term alteration of share capital. Company must be having a share capital, they must be having XYZ number of shares of this much face value. Now company wants to make changes in that. What all changes they can make? One of the most common changes, if the authorized capital is X, they want to increase that limit. So increase of share capital is a alteration. So how can it do it? So company, if they want to make any changes in the share capital, okay, which all changes also it will come. What it requires first is article should authorize, okay, and it requires a ordinary resolution. So two things that you can remember, that a company which is a limited company, okay, a limited company, mostly companies are limited, they can alter their articles, they can alter the share capital in the following ways. So there are total 5 ways. How many ways they've given you? 5. Okay, 5 ways. So the first one is if the company wants, now we're doing section 61 1 A, B, C, D and E. Okay, so what is A? If they want to increase the share capital. Second is B is they want to consolidate the share capital. Consolidate, I'll tell you what it means. Consolidate. D is basically if they want to subdivide. If they want to subdivide the shares. Okay, your C is basically if they want to convert their shares into stock or stock into shares, and lastly if they want to cancel shares not taken up, cancel shares which are not taken up. Clear? So let's see. Section 61 subsection 1 talks about alteration of share capital. 1A. Now if the company wants, if they have their authorized share capital as let's say 10 crores, now they want to increase the share capital, so they will go pass a ordinary resolution and under section 61 1A they will alter it. Now if they want to consolidate the shares, now consolidate means what? Consolidate, if their face value is 10 and is of rupees 10 each. So if a person has face value of 10 and he has 10 shares, so his holding is 100, company can consolidate all of that and make one share of 100. Instead of one share of 10, they will make one share of 100. So consolidation could be either I have 10 shares of rupees 10 each. So I have 100 rupees value. Company, what they will do, all the 10 shares they will consolidate into one, so they will merge all of them, and then there will be only one share, and that value will be 100. The share value will be 100, so the total value remains the same. So in consolidation, and when I go reverse, one share is broken down into 10 parts. The price, instead of 100 face value, it will have 10 face value. So the value remains the same. So this is if you go downwards, this is consolidation. If you go upwards here, it is subdivision. That's it. Then, so subdivision is the company may divide it into their shares into smaller parts. Now coming to your section 61 1C. Now if I have one share I bought today, tomorrow I bought one share, after that sometime I bought 3 shares. So in total I have got 3 days 3 shares. So I'll have 3 share certificates. Okay, now this is only in case of physical share certificates. If I have 3 share certificates, I can apply to the company and make it a 1 share certificate mentioning all the shares that I have. So I'm converting my shares into stock or stock into shares. Simple. And last is, if imagine I have thought that I wanted to issue, but nobody has taken up. So if the company may cancel the shares which have not been taken up or agreed to be taken up by any person, then automatically it gets diminished. So if I had thought I will issue so much, but it wasn't subscribed only, so those shares can be cancelled. So all this is called as, there are only 5 cases which is called as alteration of share capital: increase, consolidation, subdivide, stock into shares or stock, vice versa, and cancellation of shares not taken up. Now if this is there, then what is the requirement? What is the requirement? Let's see. So first thing is, under section 64 they need to file a form, that is SH7. Very important, has to be filed. So whenever the company decides to alter their share capital clause is in MOA. So this amounts to alteration of MOA. Capital clause is there in MOA. If you read section 4, subsection 1, there are different clauses in the memorandum of association. One of them is a capital clause. This amounts to alteration of share capital. So that details have to be shared to the ROC in SH7 as given in section number 64. Done. Now we come to another concept called as buyback. Now what is buyback? Let's see. So when the company wants to purchase its own securities which it has issued, it is called as buyback. For example, company had issued shares. Now they realize that they want to purchase their own securities back, so they will give the money to you and they tell them give our shares back. Whatever shares they get, they will cancel it and they would give the money to the shareholders. So in buyback, company really pays the money to the shareholders back. Now why they would do, maybe if they feel that you will sell it to someone else, so it's better that I buy it back. Someone is going to take over my company and you will sell it, so I buy back my shares. Second, if I feel that I have excess capital and I don't have any business purpose to use, then I will tell the shareholder that listen, you all take your money back, give me the shares. Complete. Now whenever the company gives a buyback, there are forms. Now pay attention. SH8 to SH11. SH8 is the letter of offer. Okay, is the letter of offer. So company, they will give an offer to the shareholders. In SH9, a declaration of solvency will be there. SH10, register of buyback. SH11, return of buyback. And SH15 is a certificate of compliance in buyback. Sir, can you make me learn? Answer is yes. SH8, 9, 10, 11 and 15. Now first is letter of offer. The letter will be given to all the shareholders that the company plans to buy back the shares of the shareholders. Anyone who is interested, they can come and give the shares to the company. This is the buyback price. Now before doing this, company has to get a declaration of solvency. that listen, I have money, I will not become insolvent while trying to pay the money to the shareholders. Then comes a register. A proper register of buyback will be maintained. Then return of buyback. So return is basically all the details of buyback. I have to file it with ROC. Once everything is done and all the share certificates that I have done, I have extinguished it within 7 days of completion of the buyback. I have to destroy all the share certificates that I have received, because now the shares will no longer be in existence. Then a certificate of compliance has to be signed by 2 directors including MD, okay, in SH15, that they have complied with all the laws given. Now that is from section 68 to 670, all the procedures and processes they have followed. Now we will see what are the points. First is section 68. Section 68 is about buyback. Okay, a company may buy back its shares out of, now the source of buyback, from where you can do the buyback. Okay, the sources of buyback. Now obviously company, in order to make the buyback, they have to remove money, so they can remove money from the free reserves, security premium. Now remember, if you read security premium, that is section 652 subsection 2, there it is written where the money can be used. In that it is written under section 68, you can do a buyback, you can pay the money received on security premium, money that you got, this you can use to pay the shareholders. And proceeds of fresh issue except the issue of the same kind of shares. So if I am taking preference, I can use this, use the preference to redeem the equity to redeem the preference, that can be done. So proceeds of a fresh issue can be used to pay the buyback amount. See, in buyback, company has to pay to the shareholders, from where they will get the money, the company. Free reserves, security premium account, or proceeds of a fresh issue they can use. Now coming to the conditions for buyback, very important conditions for buyback. Section 68 read with rule 17. Section 68 read with rule 17. First is article should authorize. Next is approval of the board and shareholders approval by special resolution. If how much the board can do a buyback? 10%. And how much company can do a buyback? 25%. But just see of what? BOD can authorize a maximum buyback of 10% of the paid up equity capital of the company plus free reserves, and special resolution, and if they want to go beyond that, then they will have to take a special resolution. So board can authorize a buyback maximum of 10% of the paid up equity capital plus free reserves. If company wants to do more, then they will have to call a general meeting, and in that they have to take a special resolution. For that they will require 25% of the paid up capital of the company plus free reserves. And this is paid up capital. So it is not only equity, it is equity and preference. So since they have not mentioned, it means equity and preference plus free reserve. This is the maximum the company can buy back. Beyond that, the company cannot buy back. So company can buy back maximum 25% of the paid up capital of the plus free reserves. Board can buy back maximum 10% of the paid up equity capital plus free reserves. Listed company can only get the shareholders approval through postal ballot. Limit, as I told you, company cannot buy back in excess of paid up capital plus 25% of paid up capital plus free reserve. The debt equity ratio, debt cannot exceed twice of the paid up capital plus free reserve, means debt ratio should be 2:1. So debt will be 2 and equity will be 1. Okay, so if I have 1, I can paid up capital plus free reserve, the maximum amount of debt I can take is 2. So this ratio should be maintained. Only paid up capital can be bought back. Okay, fully paid shares can be bought back. Now one important thing that they asked in the exam, what they said that buyback has been done, new buyback needs to be, somebody wants to do a new buyback. So what happens is, remember, to complete a buyback they get 1 year. So a fresh buyback shall not be made within a period of 1 year from the date of closure of the preceding buyback. So company cannot, they have to have a 1 year waiting period. So if a company has done a buyback today, then they have to wait for 1 year. So 1 year waiting period is there. 1 year waiting period. Clear? Completion of buyback. Buyback should be completed in 1 year. Moment the buyback is completed, then they have to wait for 1 year to do another buyback. Simple. Both of them are connected. Company gets 1 year to complete a buyback. Once the buyback is completed, a fresh buyback should not be done for a period of 1 year from the closure of the previous buyback. Buyback. Now, from whom you will buy back the shares? Obviously, I can buy back. There are different methods of doing the buyback. One could be from all the shareholders on proportionate basis, or I can do it from the open market or from employees. Open market is the stock exchange, or from employees. So I can buy back. I can tell that give the shares, my existing shareholders, I can tell them that on proportionate basis I'm offering the buyback. Second, I can do it from the open market, means I don't give a year. Letter of offer will be given. Letter of offer is given to each shareholder. And in which form? In SH8. As we saw, right? SH8, 9, 10, 11 and 15. In open market, in listed, listed companies, they put it on the stock market only. That's called as open market. Or you can even buy back from the employees. You are given ESOPs, etc. They are there. Now, once the buyback is completed, within 7 days you need to destroy and extinguish the security. So obviously you bought back the securities, they paid them. All these share certificates, I will either shred it or throw it away. Next, restriction on further issue. So one restriction was, again I cannot do a buyback for a period of 1 year. Here, after buyback, the company shall not issue the same kind of shares for a period of 6 months, except, so I have bought back the shares, now I can't do a reissue. So company cannot make a fresh issue, further issue within a span of 6 months. The further issue could be done by way of bonus shares, ESOP, conversion of preference shares into equity. This is allowed. So all this is allowed. Again, once the buyback is completed, company cannot make a fresh issue of shares for a period of 6 months. However, company can issue bonus shares, ESOPs, convert their preference into equity within 6 months also. Okay, so 6 months is there. These cannot be done. Offer period, for example, company will give a letter of offer and tell them that we are planning to purchase the shares. Do you want to sell? So they have to say a yes or no within a period of 15 offer period. Company can make the offer period minimum 15 days, maximum 30 days. Register of, we've completed SH10. Now, coming to the next thing, capital redemption reserve. So how much ever has been bought back, that much amount goes in capital redemption account. So when the company is bought back, when the company buyback is made out of free reserves of security premium, a sum equal to nominal value of the shares bought back. So how much ever is the face value of the shares bought back, that much amount will be transferred to capital redemption reserve. So this is a rule that how much ever buyback you've done, that much amount should be transferred in capital redemption reserve account. Okay, so some kind of reserve should be maintained. Next, section 70. Okay, section 70. Prohibition of buyback. A company cannot buy back shares through subsidiary, through investment company if there is any default. However, buyback is not prohibited if the default is remedied and a period of 3 years has lapsed from the date of such default being ceased to exist. Okay, market is important. This also they can ask in the exam. So first thing is, if a company wants to do a buyback, it only has to follow the laws and do the notices. It cannot be done through a subsidiary or an investment company. So this is simple, that if a company is doing a buyback, they only have to go and complete the procedure. They cannot get it done through a subsidiary or investment company. One, this is over. These both are same points. Now this is important. If the company is under a default, they cannot do the buyback. Okay, company has defaulted in redemption of deposits, debentures, payment of any interest, dividend, etc. If they are under default, they cannot do. The ban gets over when a period of 3 years lapse from such default. So if the default has been remedied, if the default has been rectified, then still they have a waiting period of how many years? They have a waiting period of 3 years. Now coming to reduction of share capital. Reduction of share capital. Let's read. Now very important, let me explain the concept to you. Let me explain the concept. Okay. Now we are going to see reduction. Now pay attention to what I'm teaching you. Okay. Reduction of share capital. It could be divided into two categories. Reduction which requires approval, which requires NCLT approval required, and the other one is NCLT approval not required. NCLT approval not required. Not okay. Now, where NCLT approval is required, that is given under section 66, which is actually called as reduction of share capital. Means the true name, reduction of share capital, is where NCLT approval is needed, and it is coming under section 66. Here. Now there is a reduction where the share capital gets reduced but does not require NCLT approval. The technical name for this is called as diminution of share capital. What it is called? Diminution of share capital. This falls under various sections. This falls under various sections. I want you to note it down. Whenever in exam or generally they talk about reduction of share capital, they always mean section 66. Reduction of share capital. Now in the second category, they have given a specific name called as diminution of share capital. Your share capital reduces, but it does not require NCLT approval. For example, buyback. When the company buybacks, they are paying the share capital is reducing. And we saw in the buyback procedure, special resolution is enough, board resolution, they can do the buyback. Second, when they redemption of preference shares. So whenever the shares are redeemed, obviously the share capital will reduce, so don't require NCLT approval. Other cases, whenever there is a surrender and forfeiture. So whenever the company forfeits the shares, obviously the shares are, and imagine they have not reissued, so share capital will reduce. If the company if a shareholder could not pay the call money, so he will come and surrender his shares. So that is different, right? So even there the share capital is reduced. Then further, if in order of court certain transfers have been made and they've given you a list, so all these are in different sections. Okay, even your under section 61 1E, okay, where they have cancelled shares which have not been taken up. So all these cases are called as diminution of share capital. Simple. Now what is reduction of share capital? Because here you require NCLT approval. So the process here are dependent section wise. Here in section 66, you have to remember, AOA should authorize. AOA should authorize. Second, you require a special resolution. And third, you require NCLT. Okay, and the forms are RSC forms. RSC forms are here. So we will do section 66. Very simple. Here, let me explain what comes under section 60. So, section 66, power to reduce capital. A company may, okay, reduce its capital by passing a special resolution if confirmed by NCLT and the article should authorize. So this you have to remember. Reduce its capital the way they want. Now how they reducing, understand. One, if the company realizes that they have excess capital, so they can go ahead and give away the money. So they can either extinguish the liability. For example, you had to pay me, let's say 10 rupees shares are there. You had to pay me 10 rupees. I say I don't need 2 rupees. I will extinguish it and I'll treat it as 8 rupees fully paid up. So what is happening is I'm extinguishing your liability. For example, you had to pay me 15,000. I realize that I don't need 15,000. I just need 13,000. So then I will tell you that 2,000 liability I'm extinguishing of yours. You just have to pay me 13,000. So what did I do? I reduced your liability. Now what is happening is company was going to get 15. Now they're going to get 13. So this is a very big risk factor, because imagine if the creditors are involved. Imagine if the creditors, okay, are intimated by NCLT and even authorities, creditors and authorities. Now what is happening is, imagine the company earlier was going to get X amount, but now they are going to get lesser than that. So the creditors will be at a high risk, because they was thinking that his net worth is 10 crores, and now after reduction it will have only 5 crores. So the creditors get scared because the debtors capital is reducing. So one is they will either extinguish the liability. Second, they will pay up, or the other method is to paid up capital in excess of what the company wants. For example, you have already paid 15,000. So then the company will refund to you. They will pay off excess capital that they feel that they have. So that the other one is called as pay. So they will pay off excess capital then they want. Then comes cancelling shares which are not represented or lost or not represented by available assets. So let's call it, you will cancel which is lost or not represented by available. For example, the shareholders had given the money. With this money, I had bought machine. I had bought a plant and machinery. Let's say that plant and machinery was lost. Someone came and stole it. Who had given me, shareholders had given money, share capital. With that share capital, we bought assets. The assets are now lost for some reason. They are lost. I'll tell you everything. So in that case, what happens? They say that from there, assets are no longer there. So they will debit the asset side. So liability side, share capital will be reduced. Another example, debtors. Let's say, for example, company had certain debtors. Debtors come on which side? Asset side. Now the debtors turned out to be like Vijay Mallya. They ran away. They became bad debts. So now we have to show a clear picture to the shareholders that listen, now the assets are no longer available. They ran away out of the country. Debtors are no longer available. They became bad debts, or the debtor died and no assets are available. So in that case, we will debit the asset side, and someone has to bear this loss, right? So share capital will be reduced. So we'll cancel the share capital. Understood? You can remember this thing that either I extinguish the liability. What do? I either extinguish liability, or I pay off excess capital. Or third, assets which are lost or not available, I will cancel. Cancel lost or unavailable assets. Clear? 1, 2, assets. Okay, so let's take for example, if the paid up capital was 10, was 8, and the share price, okay, the value of share, the price of the share, okay, the share price, issue price, the issue price was 10. So obviously your liability is how much now? 2 rupees. Paid up is 8 and issue price is 10. So you paid up 8 and the issue price is 10. So your liability is how much? Liability is 2 rupees. So what I tell the company said that listen, we don't want this. We will reduce the issue price to 8 only. Okay, to 8 only, and 2 rupees we will extinguish your liability. Here 10 is paid up and price of share is also 8. Issue price is also 8. So here what we say, we reduce the issue price to 8. The 8 rupees also paid up, 2 rupees is refunded. Simple. And here the data are not available, assets are destroyed, stolen, unavailable. So then you have to represent and reduce the capital. Now only the procedural requirements are left. Let's see. First is section 62 subsection 2. The tribunal, now I have to go to NCLT approval. Now NCLT, what they will do, they will call the creditors and call the authorities, this company's value is reducing. So shall give a notice to the application to the central government, to the registrar, RBI and creditors. See, all authorities and creditors to give their representation in 3 months. If within 3 months no representation is there, it will be assumed that there is no objection. After hearing, the tribunal may confirm the reduction if every creditor's claim has been secured, discharged, consented, or consent has been obtained. If the main thing, they'll ask the creditor, listen, this company's value is reducing, are you okay? So they will say, yeah, okay, they have given us a proper assurance, etc. is there available, so I'm okay with it. They have given me some security, etc. So then we say, okay, fine, let's go ahead. The loan amount was 2 crores and the company's value is 100 crores. So they are reducing 3 crores. They say, okay, fine, our assets are secured, that is not being disturbed. It's fine if the value is being reduced. Now filing with the registrar. Okay, RSC forms are there. The company shall deliver to the registrar a certified copy of the NCLT order. When the NCLT order comes, then that has to be given to the ROC. Okay, approved, showing all the details within 30 days of the receipt of the order of NCLT. Section 66 subsection 5, effect of registration. Upon registration of an order, the registration will take effect. Upon registration of the order and minutes by your ROC, the reduction takes effect. Non-applicability does not apply to buyback and redemption because it is not under this, it is diminution of share capital. Now let's see the form numbers, very important. Okay, RSC 1. Now it starts with company applying to NCLT. NCLT will say, oh my god, you're reducing your capital, inform the authorities and creditors. So then I will give a notice to all the authorities and creditors. Okay, and then now they will come with objections. So creditors can file the objection in RSC 3, authorities can file the objections in RSC 4. Okay, then RSC 5, company will tell that creditors, don't worry, I am giving a declaration that all your claims will be settled. It will not be disturbed. Reduction will not affect your claims. RSC 6, NCLT gives the order and this order is filed with the ROC for registration. So the form numbers are given. Okay. Then comes diminution of share capital. Diminution of share capital means company shares are reducing but does not require consent of NCLT. Examples of this: Cancellation of unsubscribed capital. So company had issued, as we saw in section 61(1)(e), that we issued but nobody subscribed. So we are cancelling that. It is, okay, understandable. Companies can predict, nothing wrong going on. Redemption of preference shares. So when you redeem the preference shares, obviously the preference share capital will reduce. Buyback, surrender, forfeiture, okay, capital reduction to pursuant to compromise and arrangement. So all this does not require NCLT approval. Okay. With this we complete with part. Okay. Clear till here? Yes or no? Any doubts? Now we will be starting with part E, last part, and we will be completing. Okay. These notes are available in the WhatsApp group, JT community. You can go and download. I've covered all the case laws, past exam questions, everything. So let's begin. Hi, so we start with your part E called as transferability of shares. Here they are talking about shares, whether it can be transferred or no. So section 44 clearly states that shares will be transferable and movable property. So you can transfer, but there can be a prohibition on transfer. We will see in physical shares. In private companies there is a requirement, some restrictions are there that they have to complete those procedures, only then they can transfer for private company, whereas for public company is freely transferable. Now transfer in physical mode. Now if physical mode is there, then share certificates are there, and share certificate has to be duly signed and stamped. Okay, this is given in your section 56. Now how you will transfer the shares? So very simple, there is a transfer deed. There is a transfer deed, okay, in SH. So transfer deed will contain the date, the duly stamped date, signing of both the parties, okay, and this, once they have signed the transfer deed, means the transferor who is selling the shares and to whom and what price, all of that along with the stamp duty is paid, and that transfer deed is delivered to the company within 60 days from execution. Now obviously everything is online, so that share transfer deed doesn't come, but stamp duty is still there. Now partly paid share. Now many students don't know, or many people don't know, that can partly be paid shares be transferred? Can partly paid shares be transferred? Answer is yes. If the company has only not called the money, what is the problem? I am transferring. If the buyer is ready to take the liability, I am telling the buyer that listen, these are partly paid, this much you have to pay. He is okay to purchase, he will pay the balance amount. He will give me how much I have paid, whatever I have decided with him. So, but a NOC is needed from that other guy. So very simple, that partly paid shares, okay, that the transfer of partly paid shares, SH5, where the application for transfer of shares of partly paid share is made by the transferor alone, the company shall give a notice. If both are signed, then it is fine, but if only transferor has signed, so then company will go ahead, file SH5 and tell the other person that give a NOC. The company shall register the transfer only if no objection is received, that too within 14 days from receipt of the notice. So company will issue SH5 to the buyer, that buyer, listen, this is partly paid shares. Do you know it? You will have to pay balance amount. Give me your consent, then only I'll register. Within 14 days, if he has to give the consent and his NOC, only then we will transfer partly paid shares. Transfer in private companies. See, private companies, there is a restriction on transfer. That restriction is contained in the articles of the company. Restriction is different from prohibition. A complete prohibition is not allowed. A private company, it is not that shares cannot be transferred. Can be transferred, but consent of the other members, etc., who is the new guy coming in, all those will be mentioned in the articles. A common practice is the right of preemption, that is requiring the shares first to be offered to the existing members at fair price. So a right of preemption is always there in private companies that listen, if I want to sell my 20% stake, so the preemption right states that the existing shareholder should get a right first to buy my shares. If not, then I can sell it off to the other people around. Now, transfer of public company. Now, transfer of shares in public company, obviously it is freely transferable, no one's consent is needed. Blindly you buy shares today, you sell it in the very next moment, it is allowed. Not an issue. Now we come to the concept of forged transfer. Now forged means what? Now in physical share certificates, if someone has forged your sign, so when the signature of the transferor is forged, it is called as forged transfer. Now since forgery is there, it's a criminal practice, the transfer does not take place. It does not change the particular positions at all. A forged transfer is a legal void. It doesn't pass the transfer because the forged document has no legal effect. The true owner constitutes to be the owner and the company must restore his name. If the company issues a certificate to the forged transferor and an innocent purchaser purchases it, the company is liable to purchase the innocent purchaser. For example, a forged transfer doesn't shift, the title doesn't change, the original guy is still the owner. But imagine if company got fooled and changed it, so the company will have to compensate, and they will have to then recover from the fraudulent person. Innocent owner will continue to be the way that is. The fraudulent guy and the company will keep fighting if there is a innocent purchaser who is paid the money. Clear? Okay. Next. So here what happens is, let's say A is there. There is Mr. A and Mr. B came in, who was a fraud guy. Okay. Mr. B was a fraud. He forged A sign, okay, and got his name on the company. The company did not know they transferred it to B, and then B transferred it to C. So now question comes that who will compensate C, because this guy is still the owner, because a forged transfer doesn't transfer only. He still remains the owner. And this guy paid money. So the compensation company will pay, they can recover it from the fraudulent guy. So Mr. A can be relaxed, even if someone is trying to forge your sign, you don't have to worry. Okay. Now death of joint holder. Let's say if on one share you can have max 4 joint holders. More 4 joint holders. Now remember, if there is one share, like how you have houses in joint owners, let's say if one share there is Mr. A and Mr. B as the joint holder. Mr. B dies, so it will go to his legal heirs. But if the company has mentioned in the article that it will go to the surviving holders, then it will not go to legal owner. Legal heir means if the company in the articles it has been mentioned that it will not go to legal heir, it will go to the surviving guy. Then if Mr. B dies, his shares will be transferred to Mr. A. So when the shares are in joint names, it depends what the party wanted. Upon the death of one, the surviving owners are recognized as the only members, okay, and the shares are registered in their name without treating it as a transfer. Okay, unless they have mentioned that they want to appoint someone else in whose name it will go. If they mentioned surviving, then articles, it would be run according to the articles. Now comes transposition of name. Now pay attention to this, whether transposition of name amounts to a transfer. So what is happening is, let's say if in one share you have Mr. A, B, C, 3 people's names is written. So always the notice of the meeting and all the communication will be made to one party only, whose name is mentioned first. Now Mr. B is saying, no, I want my name to come first. So B, A, C. So everyone says, okay, fine, let this guy go to the meeting. So B's name has come. So this is called as transposition of name, where the position of the names have been changed, interchanged. So is this a transfer of shares? Answer is not a transfer of shares. Obviously, it is just a transposition of name, where the names have been interchanged. That's all. But the parties remain the same. However, if Mr. A, B, C are there, and now they want only in the name of A and B, then this is a transfer of shares. Whenever you add a name or delete a name, the shareholding changes, right? So therefore, the proportion of your holding valuation changes, right? So then it will come. Then for this, it is treated as a transfer, and transfer deed will be executed on this. Now, death of transferor or transferee pending registration. So what do they say? That very simple, it is like a trustee. It is a holding beneficial interest. So if a pending transfer is there, pending registration. So imagine transfer deed is filed. Transferor has said transfer it in the transferee's name. And during the company gets 1 month time to do the transfer. During that any dividend is given, or anyone transferor dies, okay, or anything is there. So what will happen? So they keep it in abeyance, they keep it in the side, and they say, wait, let the transfer get completed. Once it is completed, then all the formalities can be done. So the transferee holds beneficial interest, okay, and the transferor remains the holder and stands as a trustee. So what are they saying? That imagine you paid me the money, now you are the purchaser, I am the seller. So till the process is going on, I am acting as your trustee. You are the beneficial holder, you have paid me the money, you are right, title is there. I am just acting as your protector now till the process is completed, and then finally the shares will come in your purchaser's name. Now stamp duty. Stamp duty, as as per law, is clear. Even in physical share certificates and online, stamp duty will be there. But how much stamp duty is paid, So the stamp duty is 0.15% of the consideration amount. How much? It is 0.15% of the consideration amount. Okay, if the company is refusing to transfer the name, anything, you can go to the NCLT within the time limit. Time limit is different from private and public company. If the company, okay, again, rectification of register of members. So the register of members are there. If anyone's name has been wrongfully added or deleted, the person will approach the company telling that, listen, you have made this mistake, please rectify it. If rectification not done, then the person has a right to go to NCLT. We come to transmission of shares. See, transfer of shares and transmission, very, very important. Okay, the distinction will come. Transfer is voluntary during the lifetime. I transfer it to someone, I get consideration, and I sell it off to him. Transmission is a transfer by operation of law. By operation of law. Right? Here, imagine if there is a death of the party, it will obviously go to his legal heirs. Or if there is a death, or we could say the other thing, death is there, or insolvency, company became insolvent, so then it will go to its creditors. So this is called by transfer by operation of law. The party did not will or did not give consent, it is a process of law. So it goes to the legal heirs. The legal heir will come with a will, or they will come with a succession certificate, or they will come with nomination form, and then they will claim that put it in my name. Okay, so here no transfer deed is made, law only transfers it to the surviving person. No stamp duty, no consideration, because no money is only there, flow is no money is only not involved. Death to nominee, okay, it is from the person, it has gone to the deceased to the nominee, so money is only not involved, so no stamp duty also, no paperwork also. Okay, they are saying that if it is to a widow, the board of directors might waive off the requirement of indemnity bond, and they will waive off the succession documents, because multiple documents need to be shown. But if it is a widow, like the husband died, then they will say that just give an indemnity bond, that if anything goes wrong, you are responsible, and more detailed paperwork will not be asked. Okay. Now remember that the rules for transmission is given in table F. Table F. Okay. Very, very, very important part of the. Okay. This is your distinction between transfer and transmission. Extremely important past exam question. Transfer is voluntary during the lifetime. Transmission is involuntary process. In transfer, there will be title deed and all the documentation. In transmission, there is no transfer deed. Obviously, no transfer deed, so no consideration is involved, no stamp duty. Then we saw all this stamp duty and transfer deed was for physical share certificate. But if it is electronic form, okay, so then electronic form, stamp duty is there as per rule 9A and 9B. Stamp duty is to be paid, and all the share issue and transfers will always be in Demat form. In Demat form. Okay. Now, sir, what is Demat form? Demat, very simple. Now, pay attention. Electronic. Okay. So today, if you want to open, you want to hold shares, apply an IPO, you will always require something called as a Demat account. Demat account, because by law, all the issues and transfer mandatorily has to be, whether it be private or public company, has to be through online mode only. Online mode, physical mode has been stopped. Only exception is small company. Small company as defined under section 2 subsection 85, they can have in physical mode. In physical mode. Rest everyone has to have Demat mode. Now, how to have it in Demat mode? Very simple. There is a depository. There is a depository. In India, there are only two depositories: National Securities Depository Limited and Central Depository Service Limited. There are only two depositories in India. Their job is to hold securities in electronic form. So they are the ones who are holding in electronic form. All this is done through their agents called as depository participants. Okay. Who are depository participants? Like a I don't know where you have your account. Zerodha, HDFC Securities, ICSI Securities, your Grow. Okay. Whichever app you're holding or wherever your bank is there, if they are a depository participants, any person is there, company or person is there, they will go to DP, they will tell that they will go to the DP, they will give a dematerialization request form. You have to go to your DP, the person, investor will go to depository, will file a DRF form, dematerialization request form. Then depository participant will inform the depository that, listen, this guy has come, he wants these shares, he wants it in electronic form, right? Always issue will be done in electronic form. If at all there is a very old person and he doesn't want his shares to be in online, then that person later can apply for RRF, rematerialization request form, and on his request physical share certificates will be issued. So first online shares will be there, you can convert it into physical by giving a rematerialization request form, but very rarely someone will apply for this RRF form. Clear? So the depositories are covered under Depository Act 1996. Very simple. If you read your definition of members, okay, which is given, the definition of member, that is under section 2 subsection 55, they define who is a member. So in member, they have said that if your name is there in the depository, you are a member, because depository is deemed to be a registered owner. So what happens? My shares are held with the depository. So depositories has whichever names are mentioned, they are the registered ownership, and I am the beneficial owner. Their name is mentioned in the banks of in the company's members. It will be written that NSDL and CDSL in the company's registered book. NSDL and CDSL will be written, and in NSDL, CDSL, whoever's names are there, that is my names. I am the shareholder. So I am the beneficial owner of the share, and NSDL, CDSL are the registered holders. Rematerialize Demat for request, I told you investor has to go to DP and then it will be converted. I told you rule 9A and 9B important. All the issues will only be in Demat form. Company has to file a PAS 6, a half yearly reconciliation statement, and how much are in there in Demat and physical. So a proper reconciliation will be maintained, that this much Demat, this much physical forms I have. Now this was for public companies. Okay, public companies have to have all in Demat form. Even if you go to see 9B, rule 9B, issue of securities in Demat form by all private companies. So only small companies are exempted, otherwise they also have to mandatorily issue within in physical form. Now we go to see the next thing is transmission. So if imagine a person is there, he died, and now the legal heirs are claiming, so they have to take some proof now that they are the legal heir. Either they will get a succession certificate or a probate. A probate is that regarding a will, order of court that the will is valid. Letter of administration, it is in a will if someone is there, or and the depository records the register or successor as a beneficial owner. So nomination is done, etc. So then the transmission will be done. Rematerialization, very rare that someone will want to convert his Demat into physical holding. There are two depositories, NSDL and CDSL. That is it. With this, we have completed the entire topic and the chapter. Thank you. Okay, so we have completed the entire chapter in depth, including all past exam questions. So that is it, guys. Thank you so much for your patience, for being there for all this while, and please do share it with your friends. This is the most important chapter. I wanted to complete it in one go. Okay, so you can please complete it. I have gone through the past exam question. I've ensured that I've covered all of them, including what is there in your examination. So most important chapter, I've sat and I've completed it. Please do like the video, put it in the comment section also, and share it with your friends in your study group. With this, I will wrap up the lecture. Thank you so much, guys. See you soon.